Yeah, we're going to do the, I'm just going to skip all the way to the closing arguments where you get to hear all the others, like another 7 days. Closing arguments, the verdict, and the sentencing. All right? Then we'll move on to something else. Try to find something. But here you go, everybody. By the way, man, you know the actual literal clown that does YouTube? I mean, my God. Some of the most ridiculous comments in the world. Koberger is walking into the courtroom and he smiles to one of the cops. And then he smiles at the cop again later when he leaves. And he said, how could a killer who actually killed people be the killer if he's smiling like that? Boom! And he said, octillion isn't even a number. Numbers only go up to 1 trillion. Maybe octillion if you're feeling really frisky. But octillion isn't even a number. I mean, there's 8 billion people on the planet. So how could octillion be a number? What kind of a brain? What the hell are you talking about? Wow. Anyways, it's unbelievable. I got to do a debunking of that one. That is just one of the most ludicrous things I've ever heard in my life. Okay, here we go. Someone wrote me a novel response after my comment on that video. It was 400 million paragraphs saying no way. Yeah. And the explanations they give are crazy, Looney Tune stuff. How come there was no path of blood out to the patio? Well, how do you know there isn't a path? There was techs out there all the time. How come Koberger's really tall? He's way taller than everybody. No, he's 6 feet tall. That's what his driver's license said, you idiots. You think he put a fake height? Oh, yeah, 'cause you. Okay. So he put a fake height on his driver's license to trick cops. Oh, well, why was he trying to trick cops? Oh, good point. Well, maybe he just made a mistake. That's just unreal. So here we go. Hey, thanks, K-Me up there. See if we can hit the goal today, you guys. See if we can continue. I'm gonna go to some more of a current trial or something. Maybe that hot car. See, the hot car death case isn't like the typical hot car death where your mind just gets distracted and you're doing something else. This is the ones where, one of the ones, like I say, where there's let's say a mother goes gambling, or a husband, whatever, and leaves their child in the car while they go gambling. That's an intentionally leaving of the child in the car. Like they literally chose to do that. Okay, that's different than the typical hot car death where somebody's routines change and their mind gets distracted and they pull over and then they go into the work, and then during work they go, oh my God, and they realize and they run out. It's a different level there. So let's see. Yeah, he really is. I think he's a dumb person, Paulette. Like actually dumb. I mean, I didn't realize it until just today when he literally said octillion isn't a number and that it is, the number. The reason they came up with that 5.37 octillion or whatever the hell the number is because that was the calculation made. Using with the sample of the DNA that they had. That's why they have it. It's not based on the number of people on the planet. It's just a number that this is the likelihood. That means you'd have to find 1 billion more planet Earths with just as many people on it to go find somebody that maybe has the same. Yeah. That shows you how dialed in it is. So anyways, let's get to this Conclusion of this trial. Here we go. Rosenbaum.
Good afternoon. Been together for quite a while. It's coming to an end. I promise you, after the next couple hours, the lawyers are finally going to close their mouths. You all think you have to do what you are doing. But we have a few more things that we just want to say to you before we get to that point. You all know that you've been here hearing this case in the state of Georgia versus Jennifer and Joseph Rosenbaum. We're going to review some of the evidence you've heard over the past 2.5 weeks. Ms. Young told you when we first began this that they put up a facade. What they projected to those around them, what they projected to DFACS, what they projected to Laila and Millie's family, what they projected to everyone was a facade. And ladies and gentlemen, you saw that facade continue in this courtroom. That's what we have witnessed over the past 2.5 weeks. But as the evidence has shown, and as we are going to review this afternoon, the evidence proves beyond a reasonable doubt that they are responsible for the death and abuse of Laila Daniel. And they are responsible for the abuse of Millie Place. You've heard a lot of stuff that has nothing to do with Millie Place and Laila Daniel. You've heard things about Peggy Banks. She must be a racist. You've heard about Cynthia Tate. She might be an alcoholic. You've heard a lot of stuff to try to distract you from the truth of what happened. So let me remind you, this is why we are here today. We are here today because of Laila Daniel, a little girl who died far too young. And we are here because of Millie Place, a young girl whose life has been forever changed by the 4 months that she spent with these two people. Before we get too much more to that, my job here, I hope I can at least keep you somewhat entertained while we go over the law, because the law may not be the most exciting part, right? But it is really, really important. It's important that you understand when you go back into the jury room and you start analyzing the evidence and you start looking at the law that the judge is going to give you, what your job is. So what is your job? Every juror has a duty to follow the law and fairly and accurately seek the truth. Despite what the defense is going to want you to think, your job is not to seek doubt. Your job is to seek the truth of what happened to Laila Daniel and Millie Place. You are bound by the law and the instructions that the judge gives to you. Every juror has a duty to deliberate. If someone actually back there refuses to deliberate, you can bring that to our attention. What are some of the things that you should consider when you are back in that jury room? Well, kind of put it on the screen for you. The things on the outside are things that you shouldn't be considering. You shouldn't judge this case based upon passion, based upon any public opinion, whether or not you are unhappy with the police. If you are unhappy with the police, contact their chief. If I've done something or one of my coworkers has done something that's offended you, we work for Sherry Boston, the elected district attorney of DeKalb County, and I can guarantee you that she will take it up with us. But please, please don't take that out on Millie and Laila. Any public feelings, you shouldn't decide this based upon sympathy for the defendant, whether you have any prejudices, whether you disagree with the law, and you're not to concern yourself with the penalty or punishment. So your job here is to determine whether or not the state has presented enough evidence to prove all of the charges brought in that indictment. So what are the things you should rely on? You should rely on the statements, and the various statements that you've heard. Have you heard perhaps some conflicting statements come from the defendant? Those are things that you can consider. You can consider expert testimony. What expert testimony did you hear, and what expert testimony do you believe? You're allowed to use your common sense. We did not ask you to leave your common sense at the door when you came in 3 weeks ago. You're allowed to use your common sense when you judge the credibility of the witnesses, when you judge whether or not someone is telling you the truth. Testimony of the victim, testimony of witnesses that come in here, photos and documents, you got to allow. Elements of the crime, and who has a motivation to lie? Who in this case has a motivation to lie? The defendant. These are all things that you should consider and are allowed to consider. So let's talk about some of those legal principles that you probably watched or seen when you watch Law & Order and CSI and all those crime shows. First one, the burden of proof rests upon the state to prove each and every material element beyond a reasonable doubt. And I stand here on behalf of my coworkers, and we proudly do that. We proudly stand here to prove what happened to those little girls. The presumption of innocence. The judge is going to tell you that there's a legal presumption that the defendants start this trial legally innocent. But that does not mean they are actually innocent. Because with each and every piece of evidence that we brought you, we've shown what truly happened in that home, what truly happened to those little girls. Just because there's a presumption of innocence does not mean the defendants are actually innocent. Reasonable doubt. That's the bread and butter. I can tell you that. I'll tell you a little secret. Don't tell anyone, including the media. Don't tell anyone. I used to be a defense attorney. When I first started off, I was actually a defense attorney. And the bread and butter of defense is reasonable doubt. Trying to create reasonable doubt. Trying to confuse all of you. So let's talk about what reasonable doubt really is. The judge is going to tell you it has to be reasonable. It's exactly what it says. It is based upon common sense and reason. See, once again, it's that common sense part. We don't want you to leave that at the door. It's not a vague or arbitrary doubt. I don't really know. It's a doubt for which a reason can be given. So if you're in the back, you're like, I don't really know. I don't know. That's not a doubt for which a reason can be given. We are not required to prove beyond a mathematical certainty or to beyond all doubt, because that's impossible. So what does it mean? It's the doubt of a fair-minded, which all of you are, impartial juror, honestly seeking the truth. Again, your job is not to seek doubt. I'm going to use a couple of examples as I talk to you this afternoon to try to distill these legal principles down, because I know it can be lots that have us talk about all this law to you all at once. Let's assume for a second that I had a much more pleasant job. And my job was to prove to you that the photograph that you see on the screen is a photograph of a $1 bill. And as you can see, there are various puzzle pieces on the screen. And those would be the evidence and the testimony that had been presented during the trial. Now, as you can see, there's a couple of puzzle pieces missing. And what would the defense attorney say to you? If there's a puzzle piece missing, then the state hasn't met its burden of proof. But that's not what the law says. The law says that if you take a step back, you look at that entire picture, and there is no other reasonable explanation as to what that is a photograph of, then the state has met its burden of proof. The same in this case. If you take a step back and you look at all of the evidence that's been presented to you, and there's no other reasonable explanation as to what occurred to Millie and Laila, then the state has met its burden of proof. Talk to you a little bit about direct and circumstantial evidence. You're going to hear the judge talk to you about that as well. So do a little defining. Direct evidence is things that you can see. So photographs, videos, documents. You got a lot of them to go through. Testimony from witnesses, because when a witness took the stand and raised their hand and swore to tell the truth, that is evidence that you consider. Now, there may be some conflicts in the evidence. You may have to decide who is telling the truth. Like, do you believe Dr. Dyatlov or do you believe Dr. Sperry? But those are the things that you all can take into consideration. Testimony from the witnesses, what they saw, what they heard, what they felt, and more. So that's the direct evidence, kind of that tangible things that you can see and feel. So what is circumstantial evidence? And I'll tell you this. Circumstantial evidence in the law has the same weight as direct evidence. There is no difference in the law as to circumstantial evidence. Sometimes you hear on TV, oh, that's just a circumstantial case. In the law, that means no different. What is circumstantial evidence? So what you do is you take from that direct evidence, from those photographs or witness statements, and you can infer other facts that are reasonable and justified based upon your life experiences. See, again, that common sense thing coming in. There is no difference in the law, as I mentioned. I'll give you another example. Instead of being in the middle of July, when it's been nice and hot for the past 3 weeks, let's pretend that this trial actually took place in the middle of January. And we were getting one of those random snowstorms that we get every couple of years here in Atlanta. You leave jury selection. You leave the jury service for the day, and as you're driving home, you kind of look out of your window and you see those kind of dark, ominous snow clouds that you know from your life experience. You know, those look like snow. You turn on the radio. And when you turn on the radio, you hear the newscaster saying, there's a 90% chance of snow tonight. But when you get home from listening to me and this young drone on and on all day, you are so tired that you have a glass of wine and you go to bed. When you wake up in the morning, you look out your window, and as far as the eye can see, all you see is white. You go downstairs, you open the door, you reach down, and you feel that cold white substance between your hands. You call your best friend who says, oh my gosh, did you see it coming down last night? It was absolutely beautiful. So what do we have? Well, we have the direct evidence, the things that you saw, those dark, ominous snow clouds. We have the white as far as you could see, and you could reach down and feel that cold white between your hands. You also have testimony. You have testimony of the newscaster that told you there's a 90% chance that it was going to snow. And you have the testimony of your friend who saw it come down. From all of those facts, that direct evidence, what can you infer? That it snowed last night. What's the defense attorney going to say? Did you see it? Because if you didn't see it, then you can't prove a case beyond a reasonable doubt. But again, that's not what the law says. The law says that unless you believe that some Hollywood movie company for no good reason decided to come in and spread snow as far as the eye could see to fool you in some way, that's not reasonable. But those are the types of things that they want you to believe in cases like this. You all are going to be in a position to judge the credibility of the witnesses who testify here in this courtroom. And you judge the credibility just like you would judge the credibility of any single person in your life. And I think we talked about that with some of you during jury selection. That's what you do when you judge the credibility of a witness. Do you believe that person when they got on the stand? Does it seem like they are credible? Does it seem like they maybe are being paid to say something versus someone who has dedicated their life to doing this type of work? I don't know, Dr. Sperry versus Dr. Dyatlov? Those are the types of things that you consider. Who you believe, who seems more credible to you. The judge is also going to tell you that the testimony of a single witness, if believed, is sufficient to establish a fact. If you believe a witness when they got on the stand, if you believe Millie when she got on the stand, and she had to sit in front of an entire courtroom, scared to death, having to look over nervously at the people that she used to live with that caused her fear. If you believed her, when you looked at her, that's sufficient to establish what she said. But of course, we didn't spend the past 2.5 weeks just giving you Millie's statement. We gave you all the other evidence in the case. And I have up here the words cast director to remind me of one thing. I can only bring you evidence that we have. The only people who had a chance to decide what witnesses we'd be able to bring in are the defendants. They are the ones who decided not to abuse and beat those children in the middle of Lenox Mall, the middle of Target. They're the ones who decided what witnesses would be around. We can't bring you people we don't have. The judge is also going to tell you that the date is not material. There's a lot of dates in the indictment. You're going to see that. You're going to hear it again. There's a lot of dates in the indictment. For a lot of legal reasons I won't bore you with this afternoon, but there's a lot of dates in the indictment. But he's also going to tell you that the state is not restricted to the dates in the indictment. The date actually doesn't matter. What matters is the number of times that the child was abused. And I will tell you right now that some of the dates may not line up exactly with what Dr. Darasaw testified to. But legally speaking, that may be an issue on us when we drafted it. But it has absolutely nothing to do with whether or not we have proven that all of those individual counts, and we're going to go through all that. The judge is also going to tell you that the statute of limitations means when the prosecution started. He's going to read you a thing about whether or not this case is within the statute of limitations. I can tell you it is, all right? This case was indicted in, you're going to see, 2017. That is within the statute of limitations for all of the charges that he's going to read to you. The number of counts, I said, there's some legal reasons as to why indictments are drafted the way they are. I'm not going to bore you, but I know this Mo mentioned it at the beginning. There's 49 counts. There's legal reasons for that. Your job here today is to determine whether or not the state has proven each and every single count. You also have to consider the defendants separately. So you don't decide them together, you decide them as individuals, and you also decide each count individually for each defendant. Another way just to make our lives more complicated and your lives more complicated is in the law and means more. What do I mean by that? If you see in the indictment that we have charged something that there were multiple injuries in a single count, if we prove just one of those injuries, we have proven that particular count. I'll give you an example. Count 2 is felony murder with the underlying facts of an aggravated assault being done to the abdomen, pancreas, liver, and mesentery. If we've proven even just one of those, we've proven that count. See, and means or. We have to make things more complicated. Probably why lawyers, they like to keep themselves in business, right? So let's talk now about the crimes charged. There's a lot of them, so it's going to take a little while to go through. I've kind of grouped these by the way it made most sense in the indictment to try to make it a bit easier for all of you. The murder counts. You're going to hear several different types of murder counts. Jennifer Rosenbaum is charged with murder, malice murder, and she's also charged with several different types of felony murder. So count 1 is malice murder. Count 2, felony murder with the underlying aggravated assault. Count 3 is felony murder, and there's an associated charge with that of cruelty to children in the first degree. I promise we're going to go through all these. Count 6 is felony murder, and the underlying count is aggravated battery. And just so you all know, you will have a copy of the indictment in the room with you. What is malice murder that Ms. Rosenbaum is charged with? It is unlawfully and with malice of forethought, either expressed or implied, cause the death of another human being. Okay, so what does that mean? Let's talk about implied malice. Malice may be implied when there's no considerable provocation. And let's think about that for just a second. What considerable provocation could a 2-year-old, how could they ever provoke an adult? How could they ever do something that would justify murdering them? Clearly, there's no considerable provocation to justify murder. This isn't a situation where someone pulls out a knife, pulls out a gun, says, "I'm going to kill you." She's 2. And when all the circumstances of the killing show an abandoned and malignant heart, if you are causing blunt force trauma to a child's abdomen, that is the definition of an abandoned and malignant heart. So we've proven that she is unlawfully, and with that malice, with that implied malice, we have proven that she caused the death of Laila Dane. Because again, there is no provocation that a 2-year-old could ever do to justify her murder. And when you stomp her, or punch her, or knee her, causing all that damage to her insides, how much more of an abandoned and malignant heart could a person have? Malice, to constitute murder, the homicide must have been committed with malice. Legal malice does not mean ill will or hatred. She didn't have to hate Laila. Is the unlawful intention to kill another person without justification, excuse, or mitigation. And what justification, excuse, or mitigation could there possibly be in this case? And here's the other thing, ladies and gentlemen. Malice can be formed in an instant. It's not something you have to wake up in the morning and say, I'm going to kill someone today. But when you decide you're going to punch someone or knee them, or cause that kind of internal injury to their body, you've committed legal malice, constituting murder. The judge is also going to tell you that Georgia law does not require the state to prove motive. I've been doing child abuse cases for many years now, and I still can't understand why someone would abuse a child. I still can't understand why someone would beat a child to the point where they die. It doesn't make logical sense. Dr. Messer talked to you about some of the reasons why people abuse kids. Maybe they're stressed. They have unrealistic expectations as to what parenting is really going to look like. You, I don't know, adopt a 2-year-old and a 4-year-old who have been bounced around from home to home in the past year, and maybe things aren't going exactly the way you want. Maybe being a third-year law student at Emory is a bit more stressful. Maybe all these things going on in your life have caused you to be stressed out to the point where you were taking it out on the children. Maybe this was discipline gone horribly wrong. Whatever it is, the state still doesn't have to prove the motive, because I can't get into that line. Felony murder. Jennifer Rosenbaum is charged with felony murder, and what does felony murder mean? That during the commission of a felony, so the felony being aggravated assault, cruelty to children in the first degree, or aggravated battery, a person causes the death of another human being. And see, in this case, it doesn't even matter if we prove malice or not. If you are committing a felony and someone dies as a result of it, you are guilty of felony murder. That's how straightforward this is. And under the law, aggravated assault, cruelty to children in the first degree, and aggravated battery are all felonies. What is aggravated assault? You assault another person with an object, which when used offensively against a person is likely to or actually does result in serious bodily injury. And we don't know exactly what she used. The law doesn't require us to say exactly what it was, but clearly based upon the circumstances of the injuries that you see to both girls, clearly, whatever they were using was able to cause serious bodily injury. Hands, actually, under the law, can be those kind of deadly weapons. So when you see the knuckle marks on Laila's back, those hands were used in a way that committed an aggravated assault. Actual injury under the law does not need to be shown, but in this case, it has. Cruelty to children in the first degree. You maliciously cause a child under the age of 18 cruel and excessive physical and mental pain. Here's another example where that you see in the indictment that says "and," so physical and mental pain, and means or. Malice is not ill will or hatred. Malice means an actual intent to cause the particular harm produced. So did you mean when you maybe hit Millie with an object that caused those bruises on her side that went across her buttocks, onto her back, crossing multiple planes in a patterned way? Did you mean to do that? Yes, you did. Without justification or excuse. And again, what justification could you possibly have to do that to a 2-year-old or a 4-year-old? Malice is also the wanton and willful doing of an act with an awareness of a plain and strong likelihood that such a particular action may occur. If you punch a child in the stomach, that's such a wanton act that you should know what's going to happen. You should know that something bad might come from that. Aggravated battery. Maliciously causes bodily harm to another by rendering a member of his or her body useless. Here's something then. Useless does not mean permanently useless. So if for a while, let's say for an hour or two, it hurts and you can't use your arm that was broken, or you're not walking correctly. Maybe you're having pain back here from your rib fracture. Those are, under the law, those are examples of being useless. Does it affect the way that the body part is normally used? Again, malice is not ill will or hatred. It simply means the intent to cause the particular harm produced without justification or excuse. What justification or excuse could there be in this case? We'll now go through the felony murder counts that she's specifically charged with. She is charged with committing felony murder by inflicting blunt force trauma to the abdomen, to the small intestine, to the liver, and to the pancreas. And when we talk about small intestine, Dr. Dersal talked to you about how the mesentery is a much more specific definition of the part of the small intestine that was damaged. Count 2, felony murder with that underlying aggravated assault, punching someone. So if you believe that she punched her or kneed her or did something in some way to cause that internal bleeding and she died as a result of it, the state has met its burden of proof. Cruelty to children in the first degree. If she caused pain, mental and physical pain to that child, and as a result of that, Laila died, the state has met its burden of proof. Aggravated battery. If she caused a portion of her pancreas, which was split in half, or her liver, which was gushing blood, her mesentery, which was gushing blood, if she caused those body parts to be useless, and she died as a result of it, which she did, the state has met its burden of proof. That's what we're talking about when we're talking about the charges in this indictment. And as far as how with Jennifer Rosenbaum, by committing those acts, she committed felony murder. How about Joseph Rosenbaum? He's charged with murder in the second degree. It's a slightly different charge. He's also charged with cruelty to children in the second degree. So what is murder in the second degree? Murder in the second degree means during the commission of cruelty to children in the second degree, someone dies. And here's another thing. We don't have to prove malice. I don't have to prove malice regarding Joseph Rosenbaum. Simply by committing cruelty to children in the second degree, if Laila died as a result of it, the state has met its burden of proof. So what is cruelty to children in the second degree? When such a person with criminal negligence, when the foster father knows what's going on in that household, because what did Millie tell you? He would be there when Jennifer would hit them. One time he did hit them, but she also described he would be there when Jennifer hit them. One time he put icy hot. She just kind of described it as being cold and hot. And what did we see from the search warrant? Icy hot. He knew what was going on. It was negligent of him to leave those children in Jennifer's care. And as a result of that, Laila died. That is murder in the second degree. That is what we have proven during the course of this trial. He had an act or a failure to act. How much more of a failure to act could there be, knowing that your wife is abusing these kids and you leave them in their care regardless? Party to a crime. We're going to talk a lot of, when we start going through the individual counts, we're going to talk a lot about specific acts, and that Joseph is also charged with. So what does party to a crime mean? Party to a crime means a person is a party to a crime if that person directly commits the crime, or intentionally helps in the commission of the crime, which could include covering up the evidence after the fact. So if you are putting clothes on the child to hide the injuries perhaps from those around you, if you are putting icy hot, or you're tending to the injuries instead of getting care for that child, that's aiding and abetting in a criminal sense. That's party to a crime. That's why Joseph Rosenbaum is charged in these indictments. That's what the law says he did. Knowledge on the part of the defendant that the crime was being committed, that he knowingly and willingly helped or participated. Millie said he would do nothing, but he watched. Excuse me, Millie said he would watch and do nothing. He bathed and dressed them. We had multiple witnesses say that. Even their last witness today told you that. In the weeks leading up to Laila's death, he was part of that. He saw them naked. Would put on cream that, quote, smelled like old people and got hot and then cold. Aiding and concealing older injuries by clothing them. And the day of, what do we know he did? He helped Laila go to the bathroom. Ladies and gentlemen, Dr. Dyatlov told you that not every single one of those injuries that was on Laila's body was acute. Meaning that some of the injuries were visible prior to him leaving. And in Jennifer's own statement, she said that Joseph helped her use the restroom. That's what we're talking about. Let's start going through the other charges that are in this indictment. We talked about blunt force trauma to the head. Count 10 and count 11 are the blunt force trauma to the head. And the date that's in the indictment is going to be November 17th of 2015. That is why Jennifer Rosenbaum is charged, and she's the only one charged in these counts. What it says is that causing blunt force trauma to the head by assaulting them and cruelty to children in the first degree. And Dr. Dyatlov told you that some of the injuries that happened that day were acute, meaning that they happened in a matter of hours. She can't give you an exact time. She can't tell you that it happened at 5:02, but she can tell you that some of those injuries on the head occurred that day before any of that microscopic evidence was available showing healing. Count 12 and 13 charge both Jennifer and Joseph Rosenbaum with aggravated assault and cruelty to children in the first degree for injuries that occurred prior to that day. The date that's in the indictment, again, the state's not tied to that date, but the date that's listed in the indictment, just so you can reference it, is November 15th of 2015, causing blunt force trauma to Laila's head. Dr. Dyatlov testified that some of the injuries on Laila's head, remember she had them both outside and inside, some of those injuries were at least 2 days old. That's why they're charged this way as well. Count 14 and count 15, cruelty to children in the first degree. There's a date range for those charges, for those injuries that occurred even older than that. Dr. Dyatlov testified that many of the injuries were in different stages of healing, including different ages of those internal injuries. And then you also heard from the family testifying about different times that they saw injuries to the face. We heard a lot of testimony about that. We even heard from neighbors who saw injury. Those are the days. The date range that's listed in the indictment for your reference is October 20th to November 10th. But we're talking about the older injuries. If you find evidence that there was older injuries, the state has met its burden of proof there as well. So let's look at some of the injuries that we observed during the course of this trial. Ladies and gentlemen, those are lacerations. Despite what Dr. Sperry wants to say, everything we are seeing on the screen are lacerations. Nothing. That back there, I think Dr. Dyatlov in all her years would know the difference between a nick and that large line that he wants you to believe was coming from shaving. Let's talk about the ear. That is injury. That is injury of abusive injury. It was either consistent with kind of a pulling like this, and we know from other injuries on the ears of both girls that apparently they were either pulled or kind of hit in their ears quite a bit because there's evidence of other injury. But that's an injury. That's not impetigo. Dr. Dyatlov would know the difference between that and impetigo. Dr. Messner, who was the head of the Child Abuse Pediatrics Program at Children's Healthcare Atlanta, would be able to tell the difference between that and impetigo. Again, we see the bruises on the top of the head. We see the bruises all over the head. They want you to think that Laila hurt herself all of these times in all of these different ways by bumping her head on the bunk bed. The defendant says in her interview she did it once. Once. That came from her mouth. There's clearly more than one injury on that child's head. Clearly. And they're all over. What was she doing? Just banging her head against the wall? You see evidence of under the chin and on the neck area. And here we go. Remember when Tessa was talking about this photograph? And she said, I can see a mark right there. That concerned me. What did Dr. Dyatlov say? You can see it on the autopsy. And here's the thing. You might have to look at the original photo because there's an even older one right about here. It doesn't come through quite as well when it gets projected up there. But if you go back and you look at this photo, it is clear that there's an older injury there that's almost completely healed. That's why I brought it up to Dr. Dyatlov and had her look at it more closely. We see again, injury to the back of the ear, injury to the underneath of the chin. And it's not kind of like right here where you expect a child maybe to fall and bump their chin, it's more under. That's what was concerning to Dr. Dyatlov. It was more under. That's the evidence that we brought to you, as well as the inside. Look at all the injury on the inside of her head. And I know it's not pleasant to have to look at these photos, but Laila deserves that we do. Let's talk about the back. We spent a lot of time talking about the back. So what are the charges that are relating to the back? Aggravated assault. Dr. Dyatlov testified that the bruising on the lower back was acute. She only did one punch biopsy of the back. So the entire back area, she only took one punch biopsy. But she told you that the bruising on the lower back was acute. And they asked her, could it be consistent with being punched? And she said, yeah, the child probably was being punched in her back. Count 18 and 19, that talks about some of the older bruising. She also talked about there was evidence of older bruising on the back. There was more advanced healing with early scab formation. These didn't occur at the same time. Because at the top of the back, she found early scab formation that was already starting. The date in the indictment for your reference is November 15th of 2015. And that's what we've been looking at. That's the injury. That immediately when the EMTs saw her, they were concerned. Who wouldn't be? You can see that she probably was punched. Or something like that. But you also see how they're in different, this is all the same part of the body, and clearly they're in different stages of healing. Talk about the buttocks. We'll talk about the butt in a second, but you can see the pattern that Dr. Messner talked about. And Dr. Dyatlov told you that the bruising on the buttocks was deep into the muscle. Again, this is upper back and lower back. Evidence that you've seen during the course of this trial. Ladies and gentlemen, again, you're allowed to use your common sense. How come not a single medical professional who does this for a living, not a single medical professional, has ever seen anything remotely like this? How come? Because she didn't get these injuries from the Heimlich maneuver. She didn't get them from CPR. Blunt force trauma to her chest, abdomen, and hip. Counts 20 and 21 with aggravated assault and cruelty to children again. Dr. Dyatlov examined some of these areas microscopically, and she said that the injury at the left shoulder was acute because there were no neutrophil infiltrates present. Evidence of an older bruise on the left chest per the punch biopsy, because in that case there were no neutrophil infiltrates, so it was at least a few hours old. The injuries didn't occur at the same time. They're hours apart. Hours, not minutes, not a matter of 5 to 10 minutes. They are hours apart. That's what the science showed. Dr. Sperry didn't dispute that. The science showed that they were hours apart. Ms. Rosenbaum was only saying that it happened in a matter of a few minutes. Dr. Dyatlov examined many of the bruises and injuries, but she did not biopsy every single bruise on that body. Again, the law doesn't require a microscopic examination. She actually went above and beyond, and per Dr. Sperry probably did 5 to 7 times the amount of work that a normal medical examiner would do. Because again, the child deserves that. Count 22 and count 23, cruelty to children. The healing liver laceration. Dr. Dyatlov told you it's at least 2 days old. She can't give you further out date, but what she can tell you is that by 30 days, the research shows that it would be healed. And that 30 days is actually in reference to an adult. So in a child, it might even be quicker than that. But it definitely happened while Laila was living with the Rosenbaums. Not like Dr. Sperry wants to say that it was so old. The research shows that the type of injury laceration that she had, we went through and said, remember the OIS-1 and the OIS-2, and he didn't dispute any of that. The type of injury that she had, the research shows, would have been fully healed within about a month. What we know is at least 2 days old. There's also the hypopigmented area that we've talked about. The date for the indictment is October 15th. So let's talk about the chest, abdomen, and hip. You can see the here. This is a review of everything you've seen before. And again, here's underneath the arm. It's amazing that there's not a single bruise, though, over this area of the chest that she says she was beating on so hard to try to give her CPR. Let's see, the hypopigmented area you see up here. Ms. McKee saw it a month before. Is she part of the conspiracy now? The other thing I found interesting about Dr. Sperry's testimony, when he was confronted with lie after lie after lie after lie that Jennifer gave regarding the leg, he was still like, oh, no, I mean, I can still say that this was an accident. But Ms. Mo gets up here and says, well, did you know that they were that Ms. McKee was Facebook friends with one of the family members, which actually wasn't true. Were you aware of that? And he was like, oh, no, I wasn't. But now that I know that, that would definitely cause me, I can't believe a word she says. That isn't that special. First of all, Ms. McKee wasn't Facebook friends. Ms. McKee, after hearing about it on the news, went and found a family member on Facebook and reached out to try to figure out who she needed to contact at the police department so she could go in and tell what she knew. She saw that area that was red a month before. Why on earth would she want to get involved in this? There's no external signs of punch or kneeing or punching. Dr. Dyatlov and Dr. Sperry told you that you wouldn't necessarily see that. Because when you punch someone like this, the blood vessels actually have somewhere to go. Because you need the blood vessels to break before there's going to be a bruise. But if you punch someone or stomp someone or kick someone, the blood vessels themselves on the exterior may not show anything. But boy, on the inside, it was a different story. More evidence of the injury that were all over Laila's body. And they tried to say that maybe these were from fingernails? Come on. Use your common sense, ladies and gentlemen. What did Dr. Mesner tell us about what those injuries really look like? Blunt force trauma to the vaginal area. Dr. Dyatlov testified that some of the bruising was acute. She also said that some of the bruising had lymphocytes present, so there was a bit of aging. What does that tell us? They didn't occur at the same time. Not a matter of minutes, like Ms. Rosenbaum wants us to think that all of these bruises happened. They didn't happen at the same time. This is what the medical science shows. So for these two counts of November 15th, again, the state's not restricted to that particular date. You see the injury here. And here's one of the issues, right, with their story. Why, if it's the injury maybe is from being pushed against the sink, why is this bruise vertical? Was she holding it against the sink like this? Bruises happen, the bruise pattern that you see happens by the object that it's in contact with. Look at all of the evidence here. Nothing supports what she says. The buttocks. Dr. Dyatlov testified that there was superficial, the skin, biopsies displayed mild subcutaneous hemorrhage. She said that was acute. That probably did happen within 5 hours. The date just for reference was the 17th. On the 30th and counts 30 and 31, per Dr. Dyatlov, there was deep muscular hemorrhage with neutrophils present. So in the muscle of her buttocks. She had been hit so hard that there was bruising in the muscle of her buttocks that was at least a few hours old. That's what the science says. What are we talking about? We're talking about all this occurred because of resuscitative efforts. That's what the science showed. You can see on here the bruising that she sustained. Blunt force trauma to Laila's arm. There were 7 bruises on the right arm and there were 5 on the left. You also had to look at some of the interior photos. The right upper arm had a muscular bruise, the lateral right forearm, the left upper arm, the left forearm. All of these are inside bruises that she saw. We have to look at some of them. This is the evidence of the injury. Again, if you find even one of those you believe was from abuse, the state has proven those particular counts that we were just talking about. Look at that. You can see on the inside of her body the bleeding and the bruising. Fracturing her left arm. Cruelty to children in the first degree and aggravated battery. So here's where we get into the rendering useless. Ladies and gentlemen, you break your arm, you've rendered it useless. It hurts. Despite what Dr. Sperry wants to say that, oh no, she was probably running around and maybe hurt for a couple days and then she was running around. First of all, that's not supported by the science. And it's going to hurt anyone around the child. Let's assume what he says is correct for a second. For those first few days, anyone around that child is going to know that her arm hurt. She was crying. Why did all those doctors not find it? Because it didn't happen yet. The ulnar fracture, the Dr. Darasol will tell you that it was at least 10 days old. The other doctors told you that, and they could tell that from looking at the x-rays. But it's not more than 3 to 4 weeks old per multiple doctors, not just Dr. Darasol. But you heard from Dr. Duxbury, a pediatric orthopedic doctor. Pediatric. He sees these kids every day of his life in his practice. And Dr. Darasol also told you that there was advanced healing and new bone was seen. That's what she saw in the microscopic examination. It's not a non-union fracture like they want to try to say. What did the EMTs tell us? Immediately, when they were in the back trying to do life-saving methods, they picked up her arm to stick her for some sort of medical treatment, and they noticed, what's wrong with her arm? What motive did they have to lie? Why did they want to come in here and perjure themselves? What motive? The doctors and the nurses at the ER, they could tell that there was a deformity. And everyone in here can see it. There's a deformity there. This wasn't something that she was running around with for months and months and months, but they want you to think that because it looks real, real bad if she has yet another fracture that's unexplained. This photo, what did Dr. Sperry also tell you? Dr. Darasol was manipulating it. She was actually pulling it. That's why it's coming apart like that, to take a photograph of it. She wasn't running around like that. There was healing that was going on, and you can see it in the x-ray. And I know that all of us, when we look at this, may not understand exactly what we're looking at. But that's why we have to rely upon the people who do this daily. And Dr. Duxbury and Dr. Money, the radiologist who came in here, who literally looks at x-rays probably 12 hours a day, told you that that is a healing fracture. Dr. Money may have used the word non-union simply because it hadn't fully healed yet, but he said definitively it was not, quote, a non-union fracture. He was definitive about that. That is a healing fracture, and you can see the signs of the healing kind of on the outside that I'm pointing to. That's what they look at, and they see that callus formation. The arm was healing. It was about 3 to 4 weeks old. It happened in their care. Blunt force trauma to her legs, the aggravated assault, and the cruelty to children in the first degree. Again, multiple signs of trauma, both internal and external. That's what we're talking about in these counts. Let's look at it. How about this? Use your common sense. Does this look like an injury from holding a child up? Does that look like an injury from holding a child against a sink? No. She was abused. That's how these injuries occurred. You also see other injuries on her leg. This is a back view of that. Again, your common sense, ladies and gentlemen, but you don't even have to just do that. You can also rely upon the experts who've studied this and came in here and talked to you and gave you the tools necessary to look at all these things and say this was abuse. Fracturing her left leg. Again, cruelty to children in the first degree and aggravated battery. This occurred between 1017 and 1019 is the early dates in the indictment. This was that proximal tibial fracture we heard a lot about from gymnastics. Disc fracture right here. Now, some of the doctors were concerned about the mechanism. Dr. Duxbury was concerned. What did Dr. Duxbury do? He called her back to Hudson Bridge and talked to Miss Lowe and said, weren't you concerned about this? He talked to Dr. Eames and said, weren't you concerned about this? And Dr. Eames was like, well, now that you mention it, yeah, but she's actually with you, so do you need us to do anything? We'll do it, but since she's with you, you can take care of it. So what does he do? He says, I need you to go to Children's Healthcare of Atlanta at Eggleston, to the ER. I will call up there. And she said what? I will go. That's what he said. He memorialized that in a letter that he wrote that day. Not coming in here 4 years later and saying something different. He wrote it that day. I'm concerned about the history, so I sent them to Children's Healthcare of Atlanta at Eggleston, which, by the way, is located 2 doors down from Emory Law School. So it's not even like when they say, well, did you give her a piece of paper? She knew where it was. The doctors were concerned about it and wanted there to be a further workup. But what did she do? Oh, I'm not going there. I'm not going there. I don't want those people at Eggleston questioning me. Remember what you told Ms. McKee? I hate doctors asking all those questions. He expressed concerns and she ignored them. That is the evidence of abuse. That's how you can look at this and say these were abusive injuries. She gave different stories to different people at different times depending on who you were. Notice she never told Peggy or Tessa or Miss White anything about falling at Peggy's house. Because it didn't happen. Peggy would be like, wait, they hadn't been here in weeks or months. Tessa would be like, I don't think they've been over there a long time. So she left that part out. Convenient. Interesting that this one healed so quickly, yet they want you to think that other parts of her body are just, oh, the other parts of the body can't heal at all. The ulna, that can't heal. The liver, that can't heal at all. But this one heals nice and quick. That's what we're talking about right here. That was the fracture. And the fact that she treated it this way is the evidence of abuse, that we can prove that this was child abuse. Fracturing her rib. Posterior rib fracture, all the doctors, including Sperry, testified that these are highly concerning for child abuse in children because they come from a squeezing. And not just like, ooh, I'm so happy to see you kind of squeezing. A squeezing like this, fracturing the child's ribs. That's what happened. But even Dr. Sperry said what? Oh, that's probably only 3 to 4 weeks old. Well, at least that one he agrees with everyone else. Because everyone else who looked at this also said that it was about 3 to 4 weeks old and in their care. There's the evidence of the fracture right there and the signs of healing. Now we'll talk about Miller. Cruelty to children in the first degree and aggravated battery. Her left arm. Dr. Duxbury testified it was just a few weeks old per the x-ray. They testified this would be very painful. It wouldn't be something that, she probably broke it and no one even noticed. They all testified it to be extremely painful. Well, what didn't happen? Going to the doctor. That certainly didn't happen. Maybe after she went to Dr. Duxbury and he was on to her, she was like, we're not going to go down that road again. Too many questions. Doctors and their questions. Failure to seek medical treatment is evidence of her guilt. And his too, since the party to a crime. He aided. He didn't get her treatment. He kept the lie going. He kept the facade alive. You can see that it's a few weeks old because of the periosteal reaction right here on the side of the bone. That's how they can tell when they look at this photograph, this x-ray, as how old it is. They're not just making stuff up. It's not just a guess. This is what the science is showing. Blunt force trauma to Emily's head and neck. This is count 44 and 45. There's clear evidence of bruising. Clear evidence of bruising in a highly protected area. Dr. Messer told you that an accidental injury to the neck, the likelihood of that is less than 0.2%. That's pretty low. And then you also got it on your ear, and then you also have these pattern injuries on your side that go across multiple planes. The petechiae. The petechiae come from a high impact velocity, like being slapped. Something like that, maybe it's a hand, or some type of object. That's how you get the petechiae. Experts acknowledge, including their expert, that this is highly suspicious for abuse. So let's look at it. You can see right here the petechiae along her neck. There's a closer view of that. That is evidence that she was smacked or in some way had blunt force trauma inflicted upon her neck. You can see the petechiae right here on the earlobe. You have to ask yourself, how in the world are you getting a bruise on your earlobe unless someone is pulling you or squeezing you like this or smacking you? That's what was going on. You see it on the back of her head. And what Dr. Messer told you, that's probably more consistent with kind of being smacked and the ear gets pushed in like this. How could you ever do that to a child? Her butt and back and hip, counts 46 and 47. There was clear evidence of bruising, pattern bruising. This is not from a fall down a ladder. It is across multiple planes, and it has to be a bendable object. To reach those multiple planes, it has to be a bendable object that is actually going to bend across those planes, maybe like a belt. That's the type of injury, that's the type of mechanism to cause what we see on Millie's side and her back and her butt. Now they put up Jennifer's sister to say, oh, I saw her fall the day before. But what did she also say? When she was shown the picture, she said, oh no, the bruise didn't look like that. Ladies and gentlemen, you can see what Dr. Mesner was talking about, the areas of sparing. You can see there are kind of lines, and then there's areas that are not injured. Ask yourself, how could falling down a ladder cause that? Especially when the witness said it didn't. How could it cause that across multiple planes? She would have had to fall, I guess, roll down multiple steps. That's what we're talking about. It doesn't make sense. Cruelty to children in the second degree. Last two counts. I promise I'm almost done. Count 4, with criminal negligence, cause the child cruel and excessive physical and or mental pain by failure to seek necessary and adequate medical attention for the injuries that the child suffered. So, if you were supposed to seek treatment for, I don't know, your foster child who maybe broke their bones, and you didn't do that, that's cruelty to children in the second degree. And both of them are charged, first for Laila in count 48, and then for Millie in count 49. For Laila, she had a right leg fracture, she had a left arm fracture that would be painful, as well as older injuries. In Millie, she had the left arm fracture that also would have been very painful. The Heimlich and the CPR defense. Why the Heimlich defense? Why'd she use it? No one's saying that Jen isn't smart. She's a third-year law student at Emory. She knows the mechanism. She knows how she caused that injury. And what do they also say? That kind of delay is also indicative of child abuse. She knows how she caused the injury. Oh, God, she didn't look so good. What am I going to say? Oh, I'll say she was eating, and ding, ding, ding. Now we're high. You know what's also interesting? She tells everyone from the get-go, I don't know what I'm doing. From the 911 call to the EMTs to the DFACS worker, she's telling everyone, I don't know what I'm doing. Could that be because she's laying down her defense? Sure, she did a criminal law already. They also talk to you that the pancreas is an extremely protected area. Would require a direct blow. And what did Dr. Sperry even conceded that this kind of like pushing against the side, the force would be kind of spread out across the entire abdomen. It would cause a direct blow. That's what happened that transected her pancreas. And it's extremely unlikely that the Heimlich would have done that. In the one case study that we talked about, the one time in history that has been reported that the Heimlich maneuver has caused a transection of a pancreas, the child lived. The child had no other signs of injury. The child had no other signs of injury to their abdomen. So what did Laila have? All over her abdomen. I showed you these to show you simply, you can't even see the pancreas because it's so protected. You can see pretty much all the other organs, but that's how protected the pancreas is. None of the bruises are in the area where the heart is located. Isn't that interesting? She may not have had child CPR, but I guarantee you she knew where the heart was, right? Dr. Darisaw did tell you that there was a small injury that could be consistent with CPR, but what did she also say? The amount of bleeding was so small, it probably happened when the child was at or extremely near death because there's very little blood. There's no blood pumping out from that. That right there could have actually been a small injury from CPR, but look, that's the heart itself, and that's the amount of blood that came out. Dr. Sperry, I'll leave you just a couple more slides and then I'm going to sit down. He's willing to say whatever someone will say, pay him to say. That was clear yesterday. It just was. He's no longer hired by the state, and when the defense started asking that, he said, well, a few of my DA friends may ask me questions. He never said they hire me. He said they may ask me questions. And also think about this. He said, well, I left the GBI, and he did. He left that same week. Don't you think the GBI might have had an interest in having him leave quietly? Maybe we don't want to have this get too public. Maybe we don't want to have the fact that you've been stealing from the taxpayers for years as you've gone and testified elsewhere, yet still charge your time to the GBI. Maybe we don't want that getting out. Maybe we don't want that to be bigger than it already is. Because, hey, it might affect some cases. His opinion ignores basic facts and science, and he has a history of doing that. Just think about some of the cases that we talked about where he even said it. Yeah, you remember testifying at that doctor's hearing up in Ohio where the doctor said, sure, it's fine for a legally blind man to fly. Oh, well, no, the accident was caused by a heart attack, and he based that upon where the bodies were in the airplane, even though he'd never had any training in that. That's what we're talking about here. That's what he's doing here too. He bases his opinion upon the word of Jennifer, and despite all the inconsistencies regarding the leg, he's still willing to base his decision on her word alone. That, in and of itself, speaks volumes. Don't forget, ladies and gentlemen, because in order to go along with Dr. Sperry's theory, you would have to also believe everything that Jennifer said. Don't forget about all the times she's lied, not just about the leg, but what about when she lied to all of you? What about when she lied about daycare and got caught in the lie? What about when she lied about working at Banana Republic on a certain day in question, and Brooks got caught in that lie too? It also got interesting, he changed it from accident to undetermined. Again, none of these medical professionals, ladies and gentlemen, have ever seen anything like the injuries Laila had regarding resuscitation. No one. These are just all of the injuries all over their bodies. And you have to look at all of the injuries and look at them in a constellation. You can't look at all the injuries in a vacuum. All of these injuries, all over their body, and inside of their body. Excuse me, inside of Laila's body. How unlikely, or excuse me, how unlucky, and I said this to Dr. Sperry yesterday, how unlucky were these girls? Only one reported transected pancreas from the Heimlich. Wow, that in and of itself is already unlucky. She's a medical miracle. But she also had multiple organs injured too. She's also unlucky because she also has an extremely rare non-union fracture that occurs in less than 0.2% of children ages 0 to 6. And even less likely because she has none of the risk factors, and it was in her own. Her older liver laceration was not healing as quickly as medical literature would show. That's what Dr. Sperry wanted you to believe. Right? Gosh, she's really unlucky in that way too. Her liver doesn't even heal right. The neck injuries, she's real unlucky. She must be real unlucky there too. And Millie too. Neck injuries less than 0.2% from accident. Ear injuries are extremely rare. Laila receives injuries that no one has ever seen just from resuscitative methods. And both girls have highly unlikely injuries indicative of child abuse. You have to think that these were the most unlucky girls in the world. And in one regard, you're right. They were unlucky that they were placed with the Rosenbaums. They were unlucky they ever came into contact with them. What happened to Laila in the final minutes of her life? It was a blunt impact force trauma to her abdomen. More than once, given the microscopic findings. Given the microscopic findings that Dr. Dyatlov testified to, there was more than one blunt impact force to her abdomen. She had massive bleeding internally. She had bruises all over her body that were inconsistent with the history. And that bleeding caused shock. That's what Jennifer was talking about. That's what she was describing. The shock of that child dying in front of her. The seizures, those death seizures that Dr. Dyatlov talked to you about, which Jennifer probably did observe. She died a painful and a slow death. And think about this. The last person she saw was the person who killed her. I'm going to sit down for right now. Ms. Moe will have an opportunity to speak to you, and then Ms. Young will give the final statement on behalf of the state. Thank you.
Ladies and gentlemen, good afternoon. We've been sitting here for 3 weeks now. It's taken 3 weeks and 3 attorneys to put forward what they presented to you as the simplest case in the world. We have needed Dr. Dyatlov, a number of doctors, a number of nurses, a number of paramedics, all to testify that this is obviously child abuse. Let's look at what actually happened in this case. What is this case about? It's about a rush to judgment, anger, rage, not by Jennifer Rosenbaum, but by the authorities when this child turned up dead. DFACS had to account for this. DFACS was sued. Money was at stake. People were talking about owning DFACS. To let it go by without a show trial like this would have been negligent at best. They are telling you that the medical evidence in this case is simple and clear, and these are just unlucky girls. There is nothing simple and clear about this case. Nothing. You have a woman who does not know how to do CPR, be it adult or child. you have a woman who does not know how to do Heimlich, adult or child. And this woman is put in the position that, as Dr. Sperry says, he wouldn't envy anyone being put in the position. The child is going down, she's choking, you can't seem to fix it, you try everything possible. And yes, you're giving thrusts into the stomach. And yes, those thrusts are like punches into the stomach of a little girl, because these are adult punches, not 3 fingers pressing in on the stomach. So yes, it was a Heimlich maneuver about that. Now, we've heard a lot about the fact that these injuries had to have come from abuse. When you consider, ladies and gentlemen, that we have had a parade of witnesses come in here, day after day, after day after day, to tell us that now, in hindsight, what they saw was abuse, that they saw all sorts of abuse, but they did nothing about it. Did not call authorities, did not call defects, did nothing about it. And now, with the privilege of hindsight and the privilege of necessity, they look back and say, that was abuse, that was abuse, that was abuse. Yet these folks want you to believe that Joseph Rosenbaum, he, with his educational level, his occupational level, he is supposed to know what the doctors didn't know. He is supposed to know what the nurses didn't know. He is supposed to know what the orthopedics didn't know. Joseph Rosenbaum is charged in this case for one reason and one reason only, and that is to try and get him to turn on his wife. To say he knew she was abusing the children, and let me get a better deal for this case, and let me go about my business. But Joseph Rosenbaum did not see abuse. He did not see his wife do anything. He was working 2 jobs. He came home, he babysitted the kids. If there were bruises, they were the type of bruises that we have heard about and that started this entire case. Miss Lambert saw this horrific show of force on this child and decided to have pictures taken. She saw this example of horrible abuse and decided to have pictures taken. Ladies and gentlemen of the jury, you will have these pictures out and ask you to look at them and look at them carefully and see where on earth are the injuries. And ladies and gentlemen, if Joseph Rosenbaum saw skin knees, bruises on legs, you mean to tell me he's supposed to take this child to the hospital? He's supposed to not let his wife sit with this child? There is not a single date listed, not November 15th, not November 17th, not October 10th to October 20th, not a single date when they can prove that Joseph Rosenbaum was anywhere near the children. First of all. Second of all, they can't prove that he did anything, that he watched anything, that he saw anything. And why is that? Because their witnesses are not worthy of credibility. Ladies and gentlemen, you will hear a lot, I imagine, about what Millie said. And what the state didn't want you to know is that Millie can't tell the difference between a lie and the truth. She can't tell the difference. She tells what she hears. Now, ask yourselves, how honest is the state being when they don't bring the last therapist to the stand? We have to. We have no burden. We can sit there like potted plants and do nothing. The law requires the state to prove beyond reasonable doubt. They didn't bring you the therapist who said, yes, she couldn't tell fact, we couldn't tell fact from fiction. Yes, Miss Amanda Harrell was very concerned about that because her memories were not accurate, were not true. And we're going to put that person on the stand and say to you folks, this is who you should believe. Does it mean she's a bad little girl? No. She's still cute, she's still adorable, she's still nice. She just does not have personal knowledge of what she speaks. She is repeating what she hears great grandma say. She is repeating what mom says. And how do you know that? Because of the whole starvation argument. Now, you will see on the charges as we get the indictment, there is no charge for starving any of these children. There is no charge for not feeding them adequately. So why did we bring it up? We bring it up because it shows exactly what the state did in this case. Detective Thompson is the first person to float the idea this child is thin. The next place we see it is with Millie, whose mother calls Mrs. Brown to come and talk to Millie. And as they're standing there, Millie says they don't feed us anything. Now, where do you think that came from? That came from Detective Thompson talking to Peggy Banks, talking to Tessa Clendenny. That's where it came from, and that's where it was repeated over and over. And as the hatred for the Rosenbaums grew over the 4 years, more and more such stories were being told, to the point where defects had to say, and imagine, defects having to say, therapist, please tell mom not to talk to Millie about the Rosenbaums. There's just too much talking about the Rosenbaums. And yet these folks want you to believe that Millie just came out, testified to you about her own personal knowledge. This case comes down to what happened on November 17th. And on November 17th, ladies and gentlemen, Dr. Sperry testified that it was a chaotic, frenzied scene as Jennifer was trying to save this child. In the course of doing that, she unfortunately caused damage to the internal organs by doing improper CPR, improper Heimlich, and pounding on the back, and thrusting against the stomach. And think a little bit about Laila. She is slight. She doesn't have fat on her like I certainly do. I'm showing you thrusts here. When you do a thrust with your hands on little Laila, that's going deep. And that's pressing up against the backbone. And that's causing the splitting of the pancreas. Now, Mr. Chase wants to make a big deal about the fact that there's only one study. That doesn't mean that there haven't been split pancreases. It only means that there's one study. And you need to be very careful when you go back and deliberate and think about this case. What we say, what Mr. Chase and Ms. Young and I say, is not evidence. It's argument. It's not evidence. Because Mr. Chase says something doesn't make it so. Let's talk a little bit about some of the things that he said that doesn't make it so. We talked to you about OIS 1 and OIS 2. What did that mean, and what did that have to do with anything? He engaged in a conversation about that with Dr. Sperry. We were not privy to what they were talking about. It was not explained. Was it OIS 1, OIS 2? What does that do for you? Misstatements. Miss McKee was a friend of Kimberly Smith, Laila's great aunt. She was a friend before Laila's death, she was a friend after Laila's death, and she remains a friend. And what is true is she sought information. Yes, she did seek information. She went on the Justice for Laila website and sought out information, took that information, and went to the police 30 days after the occurrence. All of a sudden, she has some tremendous evidence to present to you, and you're supposed to believe that evidence. There's no evidence before you that Jennifer talked to this woman, just her word. There's absolutely no evidence. There's just this woman's word who comes out of the shadows 30 days after the fact, volunteers information she got out of Justice for Laila, and that she got in order to help her friend prosecute Jennifer and Joseph. Ladies and gentlemen, someone has to pay, and that's what this is about. Someone has to pay. But in real life, sometimes there are accidents. Sometimes you can't place fault at the feet of a person or persons. And that's the case here. There was an accident. Dr. Messner. Dr. Messner works for a child advocacy organization. They are there mainly to represent children. They believe children don't lie. They believe children tell the truth about abuse. But what did you hear? You heard that Millie tells stories, that she fantasizes, that she repeats what she hears. Dr. Messner says there are belt marks. He's the only one who says there are belt marks. Dr. Dyatlov says, no, there are no pattern marks. I didn't see any. Dr. Sperry says, no, I didn't see any. But Dr. Messner comes up here, the advocate for children, and he sees things that you and I don't see. Dr. Dyatlov testified that reasonable minds can differ. That the conclusions she came to are not necessarily the conclusions that some other doctor would come to. And that is in fact the case. Dr. Sperry admires Dr. Dyatlov, hired Dr. Dyatlov, thinks she's a great pediatric pathologist, but she made a mistake. Her conclusions were not the right conclusions. Dr. Sperry has amply more experience than she does. And not only that, ladies and gentlemen, Dr. Sperry was not contradicted by a single soul. You did not hear anybody come from the stage, take the stand after Ms. Wells finished testifying today and said, let me tell you how Dr. Sperry is wrong, how Dr. Sperry is talking nonsense. If there was such a person, they would have produced them. If there was a doctor that could have gotten up there and said, what Dr. Sperry said is not true. What Dr. Sperry thinks is complete malarkey. If there was such a person, you'd have heard from them. But there isn't. Not even Dr. Dyatlov came here, got on the stand and said, no, this is why he's wrong. Not even Dr. Dyatlov. Motive to lie. Ladies and gentlemen, it's the American system of justice to get up here and say that defendants have motives to lie. Where is the presumption of innocence? Where is the innocent until proven guilty beyond a reasonable doubt? Immediately, because you're accused, you have a motive to lie. Did Peggy Banks have a motive to lie? She lied. Did she lie about big things? She lied about big things. She lied about Jennifer when she said that Jennifer was lying and did not say, was not told by her that Miss Lambert, they didn't want the children with Miss Lambert because she was black. That was disproven entirely, and again, nobody got up there on the stand and said otherwise. Miss Banks got up on the stand, raised her right hand, and lied to you. Now, if she will lie about whether or not she's a racist, if she will lie about whether or not she reported something to police, if she will lie about mashed potatoes, then how can you rely on her for any testimony, especially about when she got the children? Again, you heard Ms. Wells get up there and say the dates that Peggy Banks took the children in November and in October. Ms. Banks said she didn't take the children at all. But nobody got up here and said Summer Wells is wrong. Nobody got up here and said, prove that Peggy Banks got those children, and how can you believe Peggy Banks if Peggy Banks can't tell the truth about herself, sore as it may be, that she did in fact tell Jennifer that she didn't want her daughter with black people. That's what she said. She said it again to Lakeitha Billingsley, and she said it again to the third BFACS worker. Malice murder. Malice murder, you have heard, is a combination of the intent and the act to kill. The intent to kill and the act to kill. Where is the intent to kill? Where is the intent to do anything other than try and save this child? Where is Jennifer's intent to kill? They haven't shown it to you. They won't be able to show it to you because there is no such intent. And the judge will tell you that in order to find a crime occurred, you must find both intent and the act. You can't just find the act without the intent. There has to be what we call in the law mens rea, the mind's thought. Where is the intent to kill for Joseph? Where is the intent to do anything for Joseph? Except go to work, come back, babysit the girls. Has anybody said one thing in this courtroom about either of these young people having anything about them that reflects anger, that reflects malice, that reflects rage? There's been absolutely no testimony to that. In fact, the contrary is what you've heard. You've heard nothing but that these children were loved and cared for, and that they were clinging on to Jennifer, and they held on, and you have pictures. Ladies and gentlemen, we've distilled 2,000 pictures into perhaps a couple hundred. And you will be able to see the dates on those pictures, and you will be able to see how almost every date is covered, and those children are not bruised, they're not battered, they're not cut, they have no lesions on them. Dr. Sperry, who was not contradicted by anyone, told you you can't tell if those injuries are 5 minutes or 5 hours old. What you do know is they're acute. And you do know that they all happened at once, unlike what Mr. Chase said. They all happened at once. This was Jennifer's birthday. Where is the rage to come from? This was the end of finals. She's going to the Board of Commissioners meeting. Nobody has shown or proven that any of that is untrue. Where is the proof of anger, of rage, of anything bearing any resemblance to that? There is none. What you have to believe, unlike what Mr. Chase said, is that she did wake up that morning and decide, this is a fine day to beat up Laila. Laila, who bore absolutely no threat to her. Laila, who's a sweet, cute, beautiful little girl. She had no reason to do that. What she did have reason to do is to try and save that child. And she did try to resuscitate that child by pounding on its back. And remember the 911 tape, which you'll have out and you can listen. You will hear that the paramedic on the 911 call said, you do 30 presses, 1.5 inches down, 2 breaths, then another 30, then another 30. We went up to a total of 30 compressions on this little girl's chest. 30 compressions on this little girl's chest being done with the adult CPR, followed by a 200-pound man who was doing CPR with his entire hand as well. And you wonder where she got the injuries? Eric Moreno testified, and he was attacked over and over again, and he kept saying the one thing that he was taught by the military is you give breaths, and then if you know CPR, you give CPR. That's what the manual said, that was uncontradicted. That's what his bosses told him, that was uncontradicted. And that's what he and Jennifer learned in the National Guard. You don't do CPR if you don't know what you're doing. Why? Because things like this can happen. You don't know what you're doing, you're extra forceful, you're being told you're not doing it hard enough, you need to be more forceful, and you end up going through the child's pancreas. That's why there is such a thing as a child Heimlich maneuver. That's why there is such a thing as child CPR. have heard about felony murder. Felony murder is the killing of someone during the commission of the felony. And ladies and gentlemen, you will see on the indictment that you take out that there are groupings of charges for the head, cruelty and aggravated assault for the chest and buttocks and groin area. There are groupings of that. These are all counts in the alternative. You do not have to find Jennifer guilty of anything just because there are 49 counts on there. That too is calculated. That is calculated to impress upon you that, you know what, even if we can't prove the case as prosecutors, we can charge 49 times and we'll fool the jury. They'll think, if they can get 49 charges out of this, she must be guilty of something. When in fact, she's guilty of absolutely nothing except trying to save the life of this child. The state wants you to believe not only that Millie tells the truth, but that Millie is what the paramedics are not. They are not people who can foresee the future. The paramedics did not know when the child died. Whether the child died in the house, on the gurney, on the way back, in the hospital. Nobody could tell you that, except for Millie. Millie, the state wants you to believe, has the knowledge. Even though she told people she was upstairs when it all went down, she came down and saw her mother counting and pressing on the chest. But yet, she knows when her sister died, it was in the house. And, oh yes, by the way, she also knows that the organs were transected. It's amazing. She has X-ray vision. When you imbue a child with that kind of ability and say to a jury, you need to believe this child because she knew there was a transection, because she knew the child was dead, that's ridiculous. It's totally ridiculous. What happened is she heard her mother and her great-grandmother say that the organs were transected and that she must have died before she got to the hospital. There was nothing they could do for her at the hospital. She heard that. And she repeated it, as she's wont to do. She's 4 years old. Let's talk a little bit about the interviewing of Millie, because some of the statements come from the interviews. We have the first interview where she allegedly tells the interviewer, Jennifer's good to me. We go to the second interview, which happens right after the alleged death of her sister. And she says, no, they did nothing. Samantha White had asked her before, did they hit you? Did they kick you? Did they do anything to you? Did they spank you? Did they knee you? She said no. She went to the interview. She was asked there, did anybody spank you or hit you or do anything to you? She said no. Do they hit you? Do they spank you? No. And then we have the interview, the forensic interview that occurs in the dining room of Miss Lambert, the circus that occurs in that house. Children are running around, Miss Lambert's in the room, the police, contrary to what they testified to, did bring in another child for moral support. That other child is then coaching Millie to say, oh, don't forget about this, and tell them about that. The coaching is done right in front of you. Right in front of you. It's not just mama and great-grandma. You've got foster family, children, foster mothers talking in the interview. And what does Millie say in the interview? She tells us something that we should take to heart. Did you watch the news? Haven't you heard? It's not coming from her personal knowledge. It's coming from the newspapers, it's coming from what she heard. And the detectives are peppering her with questions. It's not asking her one question at a time, letting her answer. It's suggesting answers. Did you hear Laila cry? Was it a little or a short time? Now, what kind of a question is that? Was it a little or a short time? How is that not suggestive? Now, the state brought in a number of people to tell you basically, children don't lie, children can't be coached, children don't learn from what they hear, children cannot be coached. So certainly Millie was not coached. Well, Millie was very smart. And as Dr. Powell told you, if children couldn't be coached, we wouldn't have a kindergarten and a pre-kindergarten program, because that's what we do. We teach them things in the kindergarten program, in the pre-K kindergarten. Just like her grandmother, her great-grandmother, and her mother, and the Lamberts and the Browns taught her. She got it from them, either intentional teaching, or she picked it up from their conversation. But it did not come from Millie. And to sit here and say, Millie said that she was spanked by Jennifer and Joseph watched it. Nowhere did she mention that before she gets up on the stand here. It isn't said anywhere else. Anywhere where she's not coached, there's absolutely no statement like that. This is the first time she says that. Ms. McCullough came here and testified and suggested to you that Millie does know, is talking from her personal belief. But what does she tell you? She tells you that Peggy Banks is there for almost every session. And we know Peggy Banks coaches. We know Peggy Banks talks inappropriately about adult themes to children. We know that because we've heard that through testimony. And she sits there in almost every session. And we know that in between the time of the funeral and the time that she goes to Miss Lambert, she also sees her mother. Because how do we know that? Because Miss Brown testified to that. She went to their house on 2 occasions because the mother called and said, Millie wants to see you. And conveniently enough, Millie had things to say when she came. And listen to what Millie says and the vocabulary she uses. Ms. Resort said, she said, I don't know, there are bad people out there and there are good people out there and I don't know the difference. Does that sound like a 4-year-old? And I submit to you, ladies and gentlemen, it does not. These are things she has repeated, things she has heard. The state said that there were bruises that were visible to Joseph before he left the house on the 17th. Where are these bruises? We have seen the bruises that ended up, but we have seen absolutely no evidence that there were older bruises that were visible to the eye. Nobody has testified to that. Nobody has told you that they were visible to the eye. Merely that in a microscopic examination, they appeared to be older. That doesn't mean that they looked older. That doesn't mean that they looked like bruises. To suggest that Joseph should know what the experts don't know, what the family doesn't know, is a bit rich. Impetigo, ladies and gentlemen, look at the ear. You can see the crustiness for yourselves. You can see the hair embedded in the crust. You can see where the child picked at it. To say that's a burn, it's, as you will see it's got 3 separate little welts. They're a bacterial infection that she also has in her nose area. But they're going to blame Jennifer Rosenbaum for that, too. And say that somehow or another, she slapped the child on the ear, and slapping on the ear gets you a bruise on the lobe. Children scratch themselves. Children get hurt. These were rough and tumble kids. By anybody that you've heard's description, these were rough and tumble children. They got hurt. They hurt each other. They pulled hair. You want to know why there's no hair in a certain area? When you take long hair and you pull it up, there's going to be bald spots. And to the extent that those are not a lack of hair, who was pulling hair? The girls were pulling each other's hair. We're going to blame that on Jennifer Rosenbaum too? We're going to say that she's sitting there pulling their hair? Mr. Chase says to you, maybe this is what happened, maybe that is what happened, maybe she was stressed out, maybe she had a lot of work at Emory Law School, maybe she felt pressured, maybe the children were acting up. Maybe does not mean guilt beyond a reasonable doubt. Maybe is doubt. They don't know. It might be this, it might be that. To the extent that there's a might be something else, you have reasonable doubt. Dr. Sperry's testimony is the definition of reasonable doubt. Dr. Sperry's testimony, especially because it was not rebutted, nobody got up and said it wasn't true. His testimony is there was an alternative way this could have happened, and it could have gone down in the form of bad CPR, bad Heimlich maneuver, and unfortunately, the child suffered and the child died as a result of bad Heimlich, bad CPR, pounding on the back of the chest, 90 compressions, 200-pound man following that. But we want to blame the Rosenbaums, for which there's absolutely no evidence. You've heard nothing about them to suggest anything other than that they are the people that this facade is all about. It's not a facade, it's who they are. Just because they don't know people that are good and kind doesn't mean that Jennifer and Joseph Rosenbaum are guilty of a thing. Mr. Chase says, he shouldn't have put clothes on the children. He should have seen the bruises, and he shouldn't have put clothes. He should have taken the kids to the hospital. What bruises? Where bruises? All the bruises were done on the same day. Doctor said some were a little bit older, but she couldn't tell 5 minutes from 5 hours. Bottom line is they all occurred on the same day, and they occurred after he left. He can't be held to blame for his wife's CPR and his wife's attempts to save this child through the Heimlich maneuver, through the CPR, through pounding on the back, trying to get that item out of the mouth. What else does Mr. Chase say? Mr. Chase told you and tried to bring out the fact in Dr. Sperry that Jennifer had the house for 6 days before she gave a statement. But what he didn't tell you is what you know because you heard it from the police officer when he got up on the stand and said, Jennifer said there was chicken in the drain, aren't you going to collect it? So there was a first time, she did say it immediately. She said it right then to the police officer that responded, are you going to collect it? And what did they do? No, they didn't collect it. They don't care. Couldn't mean the difference between a guilty verdict and a not guilty verdict. They don't care. Dr. Sperry told you they could freeze it, they could analyze it, determine if it came out if there were gastric juices in it. Do they do that? No. Why? Because they don't care. Beware of misrepresentations. As Dr. Sperry told you, it's a horse, not a zebra. What Mr. Chase says is not evidence. Let's talk about Dr. Duxbury. Dr. Duxbury, the infallible doctor who doesn't do a thing to stop what he considers to be a violent woman who has abused a child. He doesn't call the police. He calls the former doctor to berate him about it. He doesn't call anybody to say, this Jennifer Rosenbaum left here and she didn't go to the Eggleston Hospital like I told her to. We need to ask her some questions. Let's do a welfare check. That's what he's obligated to do. That's what he takes an oath to do. That's what it means to be a mandated reporter. You don't just get to call people up and berate them, check with Eggleston, make sure she didn't go there, and then sit on your hind legs and write a letter. Write letters to cover your own rear end. And while we're at it, how reliable is Dr. Duxbury? They want you to believe the dates he gave. And what do they say? They say, oh, you know, that's what Jennifer said. Jennifer also said that she was a foster mother. And in there, he or his nurse wrote adopted. That's not correct. History of abuse. That's not correct. So why should we take his dates as gospel truth? Arrogance, that's why. Arrogance and infallibility. If it's a doctor, you can believe them. If it's a doctor, they can do no wrong. Throw her into the laws of the law because a doctor said so. But that doctor didn't have the wherewithal to pick up the phone, call the Henry County Police, and say, do a welfare check on this child that didn't get her leg fixed. And then what do we find out? We find out that this doctor doesn't cover Medicaid, didn't cover the cast, didn't cover the shoe. What else is left? So yes, she went to another facility that did cover the cast and the shoe. It's not like she didn't go get treatment, she did. There's absolutely no evidence that she didn't call Eggleston and that they didn't say there was no appointment for that day. She went as quickly as she could to where she could, to where they paid Medicaid. The state doesn't want you to know that, and neither did the doctor. Because what did he say? I don't know nothing about money. I just rake it in, but I don't know anything about money. I don't know anything about billing. But isn't it interesting, he knows about everybody else's billing practices because he tried to tell you about what other people do. His own, he doesn't know anything about. But other people, he knows their business. Ladies and gentlemen, you have out with you pictures of the bed. It's a cute bed. It's a nice arrangement, but it is what we in the law like to call an attractive nuisance, which means it's very attractive to kids to do on it what they shouldn't do on it. Just like swimming pools are very attractive nuisances, they attract kids to do what they shouldn't do, which is jump in the water. And these beds attract kids to jump on them and to try and touch the ceiling. Sometimes your hand touches it, sometimes your head touches it. And how many children have you seen fall down, hurt themselves, get right back up, go right back on the bed, and jump some more? "49 counts. Because you couldn't hold anybody accountable in less than 49 counts. Because you couldn't do a count of murder, a count of aggravated assault, and a count of cruelty and call it a day. No, because we are being driven by an agenda. And that agenda is to blame somebody for what happened, whether it be accident or not. We're not going to let defects take the hit for all of it. We're not going to let the state pay out money to this family and not have somebody to hold responsible. That's what this is about. That's why there are 49 counts. All these people that now come and tell you, oh, it was abuse. Amazing how they have 20/20 hindsight vision. But where were they? Way back when. Where were they? Peggy Banks and Kim Smith, it wasn't their fault. They didn't need to tell anybody. They just relied on Jennifer, because that's what you would do as a parent whose child was in foster care, is you would rely on the very person who you think is abusing the child. And throw your hands up and say, I didn't know, I didn't know. We call defects? No. Did we call the police? No. Did we go and talk to the caseworker? No. Did we as the mother of Jennifer, did we as the mother of Laila and Millie, did we say take the children out of the Rosenbaum home? No, we didn't. Miss Tessa Clendenny tells you she did, But we heard from the defects workers, she never said take the children out of the Rosenbaum home. And ladies and gentlemen, we talk a lot about, and we have brought up a lot about lying and misstatements. And why is it important? If you lie about the small things, you're going to lie about the big things. And here, ladies and gentlemen, they're lying about Jennifer Rosenbaum. They certainly are lying about Joseph Rosenbaum, who wasn't anywhere in the vicinity. Yet you can go back and see where they have lied and lied to you. Miss Lambert. Miss Lambert comes up with this notion, and it's interesting given that we're being filmed through all of this, we're being videotaped, whatever the modern term is for that. It's interesting that Miss Lambert comes in and says, you know, Millie told me Joseph hit her on the back. Now, you heard Detective Thompson and Detective Mellon say, be sure and tell us if she says anything. She never told a soul. Because you know why? Because they didn't ask her. That's what she would have you believe. How about evading responsibility like that? They didn't ask her. She was very willing to talk about other things, but the secrets that Millie told her, she wasn't going to tell anybody. Well, what's interesting about the fact that we're being filmed and that Miss Lambert comes up with this idea that Joseph is the one that hit Millie on the back? She sat and watched the opening statements. She's not supposed to do that. She was told not to do that. We sequester witnesses. They're not supposed to view what happens on
Objection
TV.
on this person's arguing to evidence that's not, stuff that's not in evidence. There was never any testimony that Ms. Lambert watched an opening statement or anything of that nature.
Counsel. Objection sustained.
Let's talk a little bit about Miss Hall, the nurse. This is taken 4 days after Laila fell down the stairs. You heard Miss Hall testify. She was covered in bruises. Not only was she covered in a bruise, she went to see her a day later, and she had another bruise on her face. Yet, 4 days later, absolutely pristine. Absolutely pristine. Everybody wants to be a hero. This is a small town. Everybody wants to be the one to bring people down. Where is the evidence that 3 days before this girl was hurt for the second time? That evidence is the same place where this evidence is. Non-existent. These are pictures taken November 11th. The state would have you believe that a week or two before that, she broke her arm. Take a look at that. Let's talk about Ms. Lambert. Ms. Lambert says that Jennifer took the children on June 28th. Look at what's been marked as State's Exhibit 118. And Ms. Lambert is very proud, and so are the defects, and so are we all, for the fact that she documents so well. But if you were documenting for before June 28th, why would you put it after? Why would you squeeze it in before June 21st? Here you have the June 21st incident, and then you have June 28th, which she writes on top of June 21st. I submit to you, ladies and gentlemen, she told the story about subsequent bruises. And so she documented it after the fact. And how do we know that those subsequent bruises didn't happen? The way we know that those subsequent bruises didn't happen is because there's no pictures of it. She had these two pictures taken. And then after that, there was subsequent bruising, she testified, on June 28th. Where is it? If you would go all the way to defects to have pictures taken, you would do it again if it continued. And she's so very punctilious, she's so very detail-oriented, she's not going to miss an opportunity to document any bruises that she saw. She would have taken pictures. She didn't, because they didn't happen. Banana Republic, June 28th. Their witness testified that she worked that day with Jennifer. That she checked her schedule and they were scheduled that day. Not whether or not she got paid for that day. They were scheduled that day and they worked that day. The truth, ladies and gentlemen, is in the details. And that's why I said to you in opening argument, question everything. Just like Dr. Sperry told you, you have to see the horses and not just the zebras. Question everything. Much ado is made of the fact that Jennifer has said slightly different things to different people. You've got to understand what's going on. You've got to understand that this is a young woman who has just lost a child. She is scurrying in her brain to try and figure out when this happened. She knows of one instance. Millie tells her of another instance. Does she always repeat what Millie says? No. Sometimes she just repeats what she knows, which is that she fell in gymnastics. And it's interesting that the gym tells you, it couldn't happen. She couldn't have run out onto the grounds of the gym and played on the slide or on the bars. She couldn't have done that. Yet and still, she was able to take the class without signing a waiver, which they said you have to do, you have to sign a waiver in order to take the class. But Jennifer, being Jennifer, took a mommy and me class without signing the waiver. And then she doesn't say it happened in class. She says she fell from a bar. She's trying to help the girl up to get her to grasp onto the bars, and instead the girl slides down and falls. And then is limping. So she does something about it. There's no failure to seek medical attention. She seeks medical attention. That pink cast is evidence that she sought medical attention. The state paraded 3 or 4 witnesses in here, especially Ms. Espinoza, to suggest to you that Jennifer and Joseph were not sad enough at the hospital. But then, when we brought the defects workers in, they said, yes, they were crying. Yes, they were distraught. They were both distraught. They were both crying. So what did Ms. Espinoza see? Ms. Espinoza was upset that a child had these injuries. So whatever she saw, it was not enough. But the evidence is that they were sad. They were upset. That Jennifer was crying. That Ms. Samantha White could hear Jennifer on the phone from the street. She was crying so hard. And ladies and gentlemen, people don't have to prove their sadness for other people. Everybody grieves differently. And everybody admitted that everybody grieves differently. interesting that Espinoza and Emma Carr don't see what everybody else sees, which is a very distraught and very sad Jennifer and Joseph. Millie said, seeing someone cry makes me cry. That's why I cry. Who was she with? Jennifer. Who was crying? Jennifer. And make no mistake, ladies and gentlemen, Jennifer will go to her grave distraught about this. You don't go through something like this. She will blame herself for it, whether she's legally responsible or not. Ladies and gentlemen, you're going to hear the judge tell you that the state must disprove accident. They must disprove that an accident occurred. Dr. Sperry testified that it was an accident or something undetermined. And no one came to rebut him. Not Dr. Darisaw, not Dr. Gowett, not anybody. Not Dr. Messner, none of the nurses, none of the paramedics. Nobody came in here to say that Dr. Sperry was wrong. Jennifer talked to everybody and anyone that asked her to. She talked to DFACS. She talked to the police. Even with her attorney present, they still sat there and answered every question. They were being filmed. They knew that. She answered every question. She talked to Dr. Sperry. Anybody that asked her to talk, she is more than happy to talk. She was more than happy to talk to DFACS. She was more than happy to talk to the police. She was more than happy to talk to Dr. Sperry. Beam or bars? She supposedly said beam to one person or bars to another. Ladies and gentlemen, that is assuming that the folks that are reporting this are in fact accurate as well. Could somebody have heard beam instead of bar? Surely. Does it have to mean that she said beam or bar? No. It could mean that they misinterpreted beam for bar, bar for beam. Why did we bring Detective Nawara in here? She didn't testify too much, you might say. What she testified to is that Millie said exactly what I asked Kia about. I said to Kia, isn't it true that Millie said a bear had scratched her, that that's how she got hurt? Kia said no, she looked at me like I was crazy. But indeed, we find out she told Detective Nawara that Millie said a bear had scratched her. You've got all these different statements. They want to hold Jennifer accountable for beam and bar. They want to hold Jennifer accountable for talking about a gymnastics injury when she didn't talk about it happening at Nana's house, when she didn't know if it happened at Nana's house. She just got that from Millie, who we know is not the best historian. They want you to hold her accountable, but they don't hold their own witnesses accountable to that. And Detective Thompson asked him directly, did you not ask Kia to come in for moral support? And I used the word moral support. What does he say? No, I didn't. What did you hear on the tape? Can you come in for moral support? These are shortcuts to conviction, because that's what they want you to do. They want you to convict regardless of the evidence, regardless of the fact that people have lied, that people have misstated. In a few minutes, I'm going to be handing over Jennifer and Joseph's lives to you. I've had them for 4 years. I'm just going to ask you to take as good care of them as I think I have, to care for them as I think I have. And don't sell them down the river to the first merchant that comes along. Brings you pretty pictures and says these are injuries, when they could very well be as a result of CPR or Heimlich. Again.
Hey, freaks! Thanks for reaching the goal. If you guys would like to help support the channel, make up for some of those last 2 days that we had, that'd be absolutely awesome. We got another 2 hours left, 1 hour and 58 minutes, where we get the verdict and the sentencing. All right, so if you can afford it and want to help support the channel, that'd be great. Thank you.
Not despairing. Nobody not despairing. They're in your hands. Thank you.
Court, thank you, Ms. Ball. Take a short break. I think we need to take a short break. Let's take a 10-minute back.
Ladies and gentlemen, the beginning of this case, and as my trial partner has told you, this is all a facade. It's been a facade since 2015. And the facade has continued, or attempted to continue, throughout the 2-3 weeks that we've been here on trial. Now, I'm sure a lot of people are familiar with these folks. The Turtles, case out of California, where a couple was holding their 13 children in the house, ranged from ages of 29 down to 2. And they were keeping them in that house, chained, and they were beating them and torturing them. Until fortunately enough, their 17-year-old daughter, who by the way appeared to be about 10 or 12 when the police finally got to them, said, please come help. We are being held by our parents for years. We're being beaten, we're being chained to our beds, and barely being fed. But ladies and gentlemen, the Turpins were out. They were taking pictures, going on family vacations, having wedding vow renewals. On the outside, it looked all good. But on the inside, those children told stories of horror. That's what we have here today. But the Rosenbaums, they don't do what the Turpins did, because what the Turpins did was they took responsibility for their actions, and they pled guilty. While the Rosenbaums are like the Turpins, they're not willing to take responsibility for their actions. So you know what? The state has to make them do it, and that's why we're here. Now, the defense, they have a difficult job. And like my trial partner, Mr. Chase, I once had that job, believe it or not. I was a defense attorney. And it's a difficult job. Ms. Mo has a difficult job because she has to get up here and try to convince you that these people are good people. That's difficult. They want to tell you that, oh, don't believe all these credible witnesses that have come forward, believe these unworthy of belief people that have come forward. And I'm going to talk to you about that later on. But what they want to tell you is what they want you to believe is that it's all zebras. These are horses. That's what they want you to buy. The unreasonable. But ladies and gentlemen, there's nothing that's unreasonable about the facts of this case and the evidence that has been presented to you about these defendants. They're guilty. But what they bring to you is what I call distractions, not reasonable doubt. And like Mr. Chase told you, we have the responsibility of the burden of proof. It's called a burden, but I think it's my duty. I think it's my duty to you as a prosecutor in the state of Georgia to bring you credible, believable, reliable information and evidence. The defense doesn't have that burden. So they can get up here and they can say anything they want to, no matter how much it doesn't make sense. And I submit to you that that's what Ms. Mull has done. She's brought you stuff that is not reasonable doubt. It's just distractions. But I got to talk about it just in case somebody on the jury believes some of these distractions, because I have a burden. So I'm going to talk about it before I talk about the evidence, which is what you should consider. So what are some of the distractions? Well, she kind of went away from this when at first she said this was a political conspiracy. They kind of tried to get into it with Donald Cleveland came there and said, oh, you're that Jennifer Rosenbaum. But then they let it die down because, see, there's nothing to corroborate this conspiracy because what do we know? She was an intern at the DA's office. She skimmed through the process to become a foster parent. What did she tell Mr. Odibo? Do you know who I am? You must not know. So how is there a conspiracy when she feels like she has enough political clout that she can talk to the defense worker who's talking about her home evaluation to get around things? There's no political conspiracy. And even despite the concerns of Ms. Lambert, which we're going to talk about, there were no visits that were decreased with these kids. In fact, she didn't even have to take an impact class, and maybe she would have learned the CPR that she claims she don't know, but I had an issue with that. And then she got emails from the supervisor at the DA's office. And not just the DA's office, but the judge. So there is no political conspiracy. Oh, Joseph Rosenbaum, he wasn't there, he was at work, he worked 2 jobs. How could he, oh, he's not involved, not at all. He didn't see the girls? He lived there. How could he have not seen them? He took care of them. Don't believe my witnesses, believe some of what they witnesses say, because there's a little bit of truth in every lie. And why don't they just get up here and tell you their last witness, he bathed them, he cared for them. With Kimball, she was our witness, but really she was their witness, and what did she tell you? He bathed them, he cared for them, he changed diapers, so he saw these girls. All bruises, and that's what's important, because see, they want you to believe that every single bruise on these girls happened on November the 17th. But y'all get to use your common sense. And you can look at those girls' bodies and you can tell there are new and old injuries. And he was in that house, and he saw them, and he did nothing, and that's why he sits right next to his wife. Because he's just as responsible as she is. Oh, his education didn't allow him to know anything. They know his professor in, I think, right? To talk about, oh, the girls are so well behaved. So he has enough to know if I look at a bruise and it looks yellow, that must be old. If I look at a bruise and it looks purple, it must be new. But I'm going to talk about what he actually saw in a little while. The doctors didn't even know, so how would he supposed to know? Well, first of all, the doctors didn't know initially because the injuries didn't exist when the girls was going to the doctors and seeing them. When they went to Dr. Duxbury, Laila didn't have a broken arm on October the 20th. I sent it to you that it happened after that. That's why they didn't find it. We're not asking him to find something that a doctor couldn't even find. There was nothing to find at that point. And all the bruises that we saw, the new bruises, they existed on November the 17th. But we got to talk about them old. See, they don't want you to talk about both. They want to separate them out. And then the injuries to Laila's arm, nobody even knew until they did, the medical doctors looked at it and said, EMT, that don't look right. And then they did a skeletal survey. And now, oh, we notice her arm is broken. And they want you to believe, oh, but Millie's riding her bike on November the 11th, so there's no way that her arm could have been broken. We don't submit to you, ladies and gentlemen, that the arm just stays broken. Once it's broken, you can't use it no more. Our bodies are amazing. When you don't treat them, they start to treat themselves. Her body had started to heal, and so she can use her arm. Doesn't mean that it wasn't broken, because we all know it was broken because we looked at the x-rays. And like I said, he's not charged just because we charged his wife. He's charged because he is responsible. Your failure to act is just as responsible as you're doing the act itself, especially when you're her husband, especially when you live in that house, and especially when you don't just have a responsibility to her, you have a responsibility to Millie and Laila. And you failed him. That is why he's sitting there. Due process, oh, it was a rush to judgment. Oh, they were thinking of all kinds of things. This is a complete investigation, ladies and gentlemen. So much so that this happened in 2015, we are in 2019. That doesn't feel rushed to me, and certainly doesn't feel rushed to this family, who has been waiting on justice for years. And it wasn't a rush to judgment for the Henry County, because they got off the case. They said, you know what, it's too close, we're going to step back. That's why the DA's office from DeKalb County is here. Cobb County was on the case. They said, you know what, we don't want there to appear to be a bias, some type of influence. We're going to step back. And then she talked to you about those 49 counts. Absolutely, ladies and gentlemen, because what I don't do is I don't let you slide. You're going to be held accountable for each and everything that you did to those children. I'm not going to let you slide like defects has let you slide, like your husband has let you slide, like the system has allowed you to slide. You will be held accountable for each injury that you inflicted on these children. 49 is too many, but that's why we're here. Due process, they get in their trial, they have it in their video. And I believe in wholeheartedly, because it requires for you, like-minded people, reasonable people with common sense, to make a decision on their guilt or innocence. Oh, it's the media, they just doing all of this to get the media because the cameras are here. Believe me, ladies and gentlemen, the last thing I want to do is be on YouTube. I don't want the media to be here, but the media being here has nothing to do with the facts of the case. The evidence that's been presented to you, the photographs you have seen, the x-rays you have seen, the testimony you have heard. Just because the camera's in the room, that don't change that. It's a lawsuit and it's a show trial. Ladies and gentlemen, none of that. And she says, oh, they got 3 DA's office and 3 attorneys. Let me tell you why we got 3 attorneys, ladies and gentlemen. Because it takes 3 attorneys to combat the lies of these defendants. If you notice, we each took a part. Ms. Andrews helped Millie so you can understand what she was going through. Mr. Chase was much smarter than me. He took those medical doctors because he understands it. And I take away witnesses because I know when I see a liar. Allegations of starvation. We got common sense, ladies and gentlemen. You get to use it. You look at that baby in July and look at her in November. Just to the eye, there's a difference. What did Ms. Lambert tell you? That's not the baby that I gave them in July. But don't just believe me. Don't believe Ms. Lambert. That's what she said. She saw it. She gets scared. I'm concerned. Are we doing something wrong? Not even doing nothing wrong with feeding her. It was the beating part that was wrong. Danielle Noir. Oh, we brought her in to talk about the scratch from the bear that Millie said. What was the first question out of her mouth? About Tessa Daniel. Did she tell you that she could do anything from that? That was her focus because they want you to look at Tessa. And I'll tell you, ladies and gentlemen, Tessa will not get Mother of the Year. But what I really tell you is she didn't beat her kids. She didn't brutalize them. She didn't burn them. She didn't make them eat vomit. She didn't pull out their hair. Does she have a drug addiction? Absolutely. But let me tell you something. Tessa Daniels is not on trial. They want to put everybody else on trial except for the people that are on trial. When you get that indictment, it says...
Yeah, keep in mind this is sped up. I slowed it down to 20% faster. But, yeah, take a breath, lady. I mean, my God. See, that's why the other one sounded fast, too. But she was even slower than this one. All right, so come on. Say the same thing to her. Say, take a breath. Come on, everybody. You can do it. I can't, Gray. I like her.
Rosenbaum. You won't see Tessa Daniel's name on there. You won't see Peggy Banks' name on there. You won't see Patricia Lambert's name on there. And you certainly won't see Millie Place's name on there. Donna Ward's, oh, we had to bring, they didn't want you, ladies and gentlemen, she was our witness. You see, we was orchestrating a lot of people. And Ms. Ward, she had to go out of town the day we were going to call her. So we said, ma'am, we're not going to keep holding you up because we've held up a lot of people's lives with this trial. So it's not that we're trying to hide anything from you. It takes a lot for this to happen. The defendant's crying at the hospital. I submit to you, ladies and gentlemen, they already knew about that bruising and they knew they was going to have to explain. So those tears are lack thereof because I'll let y'all decide about those tears. But the crying or the wailing that Samantha White says she heard for herself, that was for Jennifer Rosenbaum. Because she knew the facade had been unrevealed. They can see it now. You can't hide it under clothes no more. You can't hide it and put the filter on the picture no more. You're being called out for who you are. They said they gave him healthy food, ladies and gentlemen. I hope you heard it came from the jail. They didn't see the chicken nuggets from the jail. I mean, take it for what you may. Oh, the family trusted them because they believe the facade. They bought into it. What did they tell you at the hospital? Even at the hospital, they are embracing them. They are crying for them. These people believed them. They trusted them. And now they want to badger them and make them feel bad about trusting them. You can't have it both ways. This is what you put out. Believe me, trust me. But when they started to figure out, it's just a front. What did they do? They called the police and said, you know what, now that I think about it, some things that I saw, and ladies and gentlemen, they didn't see Laila's back. They didn't see no x-rays of broken bones. They saw bumps and bruises, and she gave explanations that most people would say, oh, okay, that sounds reasonable, because they didn't know who they were really dealing with. But when they did, they called the police. And they brought in everybody here, they took them out in public, oh, they did all these wonderful things. When they went out, they had clothes on. And most of these people said, I didn't even see them close in time to when this happened, and if I did, they had clothes on. I wasn't changing them, I wasn't taking care of them. And I know there was a couple of people who came here and said that. I'll talk about them later. And the girls loved them, and I'll talk to you about why, because you heard from Anita Whitmore, kids still know they're abused, and you have your comments, and there are kids that are being abused over and over again, unfortunately, but they cling to their abusers because they're young, they're inflicted, they don't understand. You have people, grown people that are involved in domestic violence relationships that still do the same thing, no matter if the person is beating them, because it's confusing. This person's supposed to love me, but they're beating me, I don't understand, and definitely at 4, at 2, you're not going to be able to figure out what do I do with this? Pictures. They brought in a whole bunch of pictures that they wanted to show y'all. They look nice, but what did Millie tell you? When she was living with the Rosenbaum, I was sad. So the pictures are nothing more than a political prop. She took these kids to meetings, to law school, to commissioner board meetings, young Republicans meetings, all as a prop. She's running for office, and what looks better than a child from foster care that now I'm fostering these 2 kids whose mom is so horrible, and I'm giving them this good life. I'm putting them on these pretty clothes. I'm putting bows in their hair. I'm taking them places, and what did that baby say? The only one who's still here to talk. I was sad. Because she knew that it was a facade. It was a front. Wild accusations. They said we was gonna give you wild accusations, ladies and gentlemen. I think they rolled out the punches. And they continue to roll them out all through closing. Daycare, seatbelt, orange juice, diaper rashes, bikes, jumping on the bed, ladies and gentlemen. We're not talking about multiple jumps. She got bruises in the front of her head, on the top of her head, on the side of her head, on the back of her head. It's unbelievable. It's unreasonable to think that that's what happened. And yesterday it was a kicker, and sometimes I try not to let my emotions get to me, but when they said it came, too much. It's despicable. It's distasteful. But that's what they're doing, because that's who they are. Patricia Lambert, she's not on trial. She saw bruises on those girls, and no matter how small they may seem to you or to the defendants, it was huge to her, because she said, I didn't send that baby looking like that, and you brought her back here looking like that, and that's a problem. And she says, oh, well, she told me that Joseph was spanking her and they were being dragged down the stairs. Millie was with her for 3 months after this happened. And you heard from everybody, Millie would just sometimes just say something, just spontaneously. So did she think, oh, I'm gonna go pick up the phone and call the police right now? So maybe no, she didn't tell the police, because maybe when they were sitting at her kitchen table, Millie hadn't made those disclosures yet. But for 3 months she was there. And then you hear after that, she's still continuing to disclose. And if you remember what Ms. Whitmore said, I think she's testified before, it's like an onion, it's layers. It comes out in layers. They don't disclose all at once. They don't sit down and say, let me tell you, blah, bit by bit by bit. And I submit to you, ladies and gentlemen, we all still don't know all that happened to that baby on their watch. They said she's here because of the media. She won't get her 15 minutes of fame. What did the people tell you from defects that they wanted to bring in? Because I think at first they were trying to insinuate that Miss Lambert was abusing her, and when that got knocked down because the case was unsubstantiated, oh, now she's here because she wants to be on TV. What did they tell y'all back then in 2016? She said, I can't take it no more. The media is calling me, they want interviews, they're asking too many questions. I'm done. I don't want to be involved. So for them now to say that she's here for some media employee is disingenuous. And Peggy, she's a racist. I don't know, ladies and gentlemen, what she is. But I would submit to you that maybe it's embarrassing to come in here and speak in public and say, I said I want my kids with a white family, I don't like homosexuals, and that she didn't fess up to that. But ladies and gentlemen, I would say to you, last I looked, KKK, they wear them white hoods on over their heads, because they don't want nobody to know who they are. They want to hide their identity. So is it embarrassing for her to come in here and say, I said those things? And I would say, she didn't say exactly that. She said, I prefer them to be with a white Christian family. They have interpreted that she's a racist. Maybe she just wants her kids to somebody they've been through enough. I need them to be in an environment that they know, people that know them. And let's all be real. It may not be politically correct, but that's what people prefer, because it's a commonality that you have. Does it make it wrong? That's not for me to judge, and I would submit it's not for you to judge. She was trying to keep this baby, fighting for 2 years, and then ultimately she said, I'm going to relinquish her, I'll give her to Amanda. What she is guilty of is maybe having inappropriate conversation in front of Millie, saying things that she shouldn't have said, talking about death in front of Millie, talking about the custody issues that was going on. But at no time has anybody said that Peggy Banks told Millie to tell lies about what the Rosenbaums did to her. Never. But they want to insinuate that so you can be distracted. Never said she told her to lie. She disciplined her with a fly swatter, and I think yesterday they was trying to say it came. Disgraceful. She was attempting to save Laila's life. A lie. The EMT caused the injury. She was dead when they got there. So any injury you saw on that baby was inflicted by her. The Heimlich CPR, I submit to you, no, the Heimlich didn't kill her. No, CPR didn't kill her, because she didn't do it. Did she knee her? Did she punch her? Did she stomp her? That's what she did when she got in the kitchen. When she was flailing and her eyes are rolling back in her head and she's pale, that's what she sees. I don't think she ever patted her on the back. I don't think she ever pressed on her stomach. You get to listen to the 911 call and see that she sounds like she's been breathing hard, pressing hard. I say no. And I think the most despicable thing of all, Millie is a liar. That's what they said, ladies and gentlemen. They brought witness after witness after witness to call that baby a liar. She told Whoppers, I have 2 children. My son lies about cleaning up his room and brushing his teeth every day. He turned 13 today and he's still doing it. But does that mean if he comes and tells me that somebody did something to him to hurt him, that I'm going to say, well, you know, you lied about that, so you must be lying about this? That's unreasonable. Peggy and Amanda, well, they brought in the twisted ankle. She didn't even talk about it because it really don't make no sense to talk about it. But I just put it in there because who knows what they're going to talk about. They're caring for a child with trauma. Millie is telling them things that sounds outlandish and outrageous. I get whippings for falling asleep in the car. So if she's telling them things that they don't, in their minds, feel like, that's crazy, because they're not abusers, it could seem like, is she really telling the truth? Or is this something else? What did the doctor say? She fantasizes to remove herself from traumatic memories. So when she starts talking about bear scratching, I think it's much easier for a child to think about bear scratching than the person that they call Uncle Jason or Mr. Joe. Let me try to take that out of my mind because it hurts too bad. It's too hard to think about. Coping mechanisms, that's what Donna talked to you about. She manifests her memories about her biological family. Who wouldn't want to do that? When you come from, you've been moved from pillar to post, your mom's on drugs, your dad's in jail, would you start making up stories about, oh, my mom's a nurse, my dad's a doctor? Because and especially when you're in school and other people are talking about their parents, you want to fit in, you don't want to be that oddball out, especially when you're 6 or 7. So is she making up stuff that's not true? But what does she tell you is always positive stuff, not negative, like they want to make it out to be. Repeating truthful information. Laila's pancreas was split in half. It's not a lie. And they talked about her not disclosing early on, and they put, I think, Mr. Powell to talk about the multiple interviews that she had. But what did he tell you? Oh, I'm not up on the most recent studies. And Ms. Andrews pointed out, well, you heard that multiple interviews have shown that you have less likelihood of having false reports. Because as my grandmama said, the truth is the truth is the truth. No matter how many people ask you, how many times they ask you if it's the truth, it's going to remain the truth. See, they don't understand that, but we're going to talk about that later. Because when they get asked certain things, it keeps changing, it keeps evolving, like lies do. Family influences, they want to tell you Millie is saying these things because Peggy told her to say these things. Who was her first exposure to? 12-year-old Kaya Lambert, when she was back in a place where she felt safe. Not to Peggy, not to Tessa, not to Ms. Brown, but Kaya Lambert, the child. So I guess Kaya is lying now. Everybody's a liar except for those two sitting over there. But you know what? Millie's not a liar when it benefits them. Oh, well, first of all, not until she started telling the truth about them did she become a liar. On all those 3.5 months that they had her going to talk to Miss White, never did they say, you know what, we're having a problem with Millie telling lies. But when she said, oh, Joseph never abused her, believe Millie when she says that. Oh, we failed at gymnastics. She's not lying about that. They were fell in the hole when it's convenient. That's when they want you to say, oh, well, no, she's not a liar about that. And I think it was really important. They showed her, I don't know how many pictures. And I've been doing this for a long time, and I do child cases. Never have I seen a defense attorney put a child through almost an hour-long cross-examination. It's distasteful, and it made me angry. Why would you put that child again and make her look at picture after picture of probably the most horrific time of her life? That's just how little humanity you have. A facade, ladies and gentlemen. It looks pretty on the outside. But that's what was going on in the inside. These children experience things children should never have experienced ever in their life. Ladies and gentlemen, my job is to talk to you about evidence and what's credible in this case. What you should believe. I thought Ms. Moore said some real interesting things. She stood up here open and steel line to tell you about evidence that was never testified to. The defendant's more than happy to talk. She talked to everybody. I will submit to you, every time she opens her mouth, a lie comes out. And if they lie about the little things, they'll lie about the big things. And that's exactly what they do. The injuries Ms. Lambert saw. At first they tried to say, oh, those were old injuries. They were from the other foster parents. That had nothing to do with us. But then Ms. White came back and said, no, we had a conversation about the injuries that Ms. Lambert saw. So we know it had nothing to do with when they were with the Browns or stuff that was going on in Ms. Lambert's house. In fact, I think several defects workers coming in and said, Ms. Lambert is exemplary as a foster parent. I mean, more like her. And what did Ms. Lambert tell you? The defendant said when she confronted her about those injuries, defects cannot give me kids and expect that they don't come back without injuries. Oh, she didn't say that. So Ms. Lambert's a liar. I would submit, and you get to decide who's credible, but I would submit to you that Ms. Lambert is credible. And now they tell you, oh, that's not an injury, that's not a bruise, that's not, but I would say right here, ladies and gentlemen, that's not normal. And Ms. Lambert said she didn't look like that when she left my house. And the pictures were taken on July 9th, not on June 28th. They were working at the Banana Republic. Because see, June 28th became such a big deal because Ms. Lambert notated in her documentation that this happened on June 28th. And if you look at Ms. Lambert's documentation, on the bottom it says June 21st, and that's talking about Ms. Newman coming for counseling, and then she goes back up and puts in what she remembers going on with the girls because that's where all of her information about injuries are. And it really doesn't matter, ladies and gentlemen, because it's a picture of what she saw. Pictures of scrapes on her hand, bruise under her eye, a burn in her hand, but they don't want you to think about that. But they want you to forget about the lie that they told. They were working at the Banana Republic. And I'm glad I got a whole bunch of people working with me because we got to keep up with these lies. So we got to run out, we got to find somebody from the Banana Republic. With Kimball, yes, she was our witness, but I'm sure it's quite clear that's her friend. That's where she stayed, just like Summer was when she was here. That's who brought her to court. And what did she say? Oh, we were working. She didn't say, oh, I was just scheduled and we were going in, but we weren't going to get paid. That's just unreasonable to think. I'm going to work, but I'm not getting paid. I tell you what, Sherry Boston will pay me. If I show up, she going to pay me. But then what we find? She wasn't there. Lie about the little things. And these pictures, ladies and gentlemen, you'll see them with women that weekend, doing hair, getting nails done. Why are you lying about these little things? Because there's bigger things going on that you don't want nobody to know about. They bring in witnesses that don't even have all the evidence. People are like, oh, I didn't know she had a broken leg. Oh, I didn't know she had a broken arm. Oh, I didn't know she had this. Why would you bring people in here and you haven't given them all the facts? They haven't had contact. We kept asking, what dates was that? So September? Okay, we talking about October. Thank you very much. Go home. What are they doing? Why are they bringing these people in here? Distractions, lies. They were always dressed. Then you had some people come in, oh, they were well behaved. Oh, some people, oh, they was running around. We had to watch. Which one is it? See, what you can't do is keep a lie straight. Once you tell a lie, you forget the last thing you said, and then you start adding something or taking something away, because a lie is ever revolving. And that's what you've seen their lives just continue to evolve. They brought in Joyce Spears. I don't know, maybe they were saying it was a rash that caused that scar on her stomach, but she can't even tell you what girl it was, when it was. Just distraction. Just, I don't know. And then, ladies and gentlemen, my heart started beating. I was like, oh, shit. He's a daycare owner. This we can find out. What that lady said? Oh, no, they didn't know about daycare. Why are you here? Lauren Banks. She fell off the ladder. Really, ladies and gentlemen, they brought in a picture of the ladder, great. And it's been up there for 4 years, a lie, a lie, a lie, a lie. But it's a picture of those girls in that backyard, and I want you to look at it, because it's hard to flip back and forth. I want you to see if you see a picture. When they out there with their bathing suits on, is there a ladder leaning up against anywhere? It's not, because it didn't happen. But what I found very important was, she said, nah, that's not what that rooms look like to me. But what I found, they didn't ask her, well, did you call defects? Did you call the police? You know, I think it was her sister. I'm sorry to lose track. It's been a long 3 weeks. But that happened in 2015. You know your friend, your family member, your sister is sitting here charged with murder and child abuse. You never said, let me call somebody and say, hey, wait a minute. Those injuries on Millie, that happened the day before. They didn't do that because that's not what happened. Lies. The patterns that you get to look. A ladder looks like that. Those lines are going like this. It's not consistent because she didn't fall off the ladder. What happened is that Jennifer Rosenbaum, she wasn't getting dressed on time. Hurry up! Bam! That's what it's consistent with. Kim DeRozio, I don't know if a kid would be happy with those bruises. Just fine. And Mary Rosenbaum, she came in here, that's his mom, Jennifer Rosenbaum, Jennifer McDaniel. Oh, but every time we saw them, they had clothes on. Oh, I didn't even know about the broken arm. You don't tell your mama that baby had a broken arm and that's what you accused of? Because she said, oh, no, I would have been concerned. You don't tell your mama that your wife told 5 different stories about how the girl broke her leg? It would be concerning. But then she waffled back, oh, that injury on Billy, it looks like a rash. It's always a little bit of truth in our lives. I had fun with this movie, though. You in the military and they didn't teach you to do compressions. Really? He said, I've never been in the service, but I wouldn't want to serve with him because he's going to leave it there to die. But what is important, he said they went to South Dakota, and see, they made a big deal about these fighting ranges, but I hope you remember, and I hope you were taking copious notes, because what Peggy said is that they said they took the girls, and I asked Millie about the flight. Millie was confused, and Jennifer said, oh no, we ended up having to drive because we had to give Jennifer McDaniel the ticket. What did Jennifer McDaniel tell you? I was here in Atlanta. I was watching the girls. He got honorable discharge, ladies and gentlemen. I question that. The prosecutor wouldn't want to work in my office because you don't know how to evaluate a case. The defendant is lying to you, there's evidence of abuse over and over again. You're like, oh, I don't know if that would concern me. You shouldn't be a prosecutor. Go be a defense attorney. Somewhere else. We finna have it. She finna come in, she finna tell it to us all. First of all, I hope y'all notice, because what you get to evaluate is the demeanor. Did you see her attitude? And Miss Andrews is as nice as one of us all sitting at that table. Give her attitude from the moment she asked her a question, because you get defensive when you're getting ready to lie. She lived 30 miles away, which probably, in the land traffic, the hour, but she won't take she up here all the time. We go to all these events. She lying. She stayed with them last night. They didn't talk to each other. They drove in the car. They didn't talk to each other. Stop it. She had seizures. Now, we shut it down, but I want you to, if she had seizures, they would brought a doctor in here, because the doctor is all you need. Nothing. Oh, they went to events together. They went to, they picked her up from Nana's house. She the only person who came in here and said they was at Nana's house on October 15th. Because see, they got to conform their lies to the evidence that has come out. Because what did Nana and Kim tell you the last time they was there? And I think Samantha White told you, good God, that was a hard direct. But I think she finally said, no, the girls hadn't been there in weeks. And Sarah McKee and Kim, they're friends on Facebook and they keep lying. Sarah McKee said, I didn't become friends with her until I was reaching out, trying to find out who can I tell with this information that I have that I think is real important. Because see, they witnesses don't recognize that. They have real important information, but they went into trial 4 years later to come tell you. But Sarah McKee didn't wait. And then she said, yes, after that, because it's a dead baby. Now, all of a sudden, she remembers it was with Peggy, and that there was Laila was walking on the 17th at Noah's Ark. Showed me a picture, and they showed you a whole bunch of pictures. I ain't seen that one picture of her walking nowhere. If they had it, they would have showed it to you. They don't have it because it doesn't exist. And they would tell you, oh, her arm was fine, blah, blah, blah. We didn't say her arm was broke on October the 27th. We gave the date range because I don't know when Jennifer broke her arm. She ain't told us when she broke her arm. The Grinch event. Laila was at the square. Don't believe me. Jennifer words. When Tessa's asking her, what about Laila? You sent me the picture of Millie dressed up like Millie who? Then she said, no, she's been sick, so didn't go with us to the Grinch. Not my words, hers. See, when you ask somebody to lie, you need to tell them all the details. They in daycare at the small group at the church on Wednesday nights. What did that lady tell us? 7 p.m. And we're going to get to that lie later on and how we know it's a lie. Joseph Rosenbaum. But she did a little bit of truth. A little bit of truth. He helps with the girls. He communicates. They know everything that's going on with one another. He does. And he knew his wife was beating those kids, and he did nothing. Their defense expert, Mr. Powell. He didn't even have all the facts. You going to bring your expert in here? Should you tell him everything? And then, ladies and gentlemen, I hope you listen to his CV, his resume. There was sexual abuse. This is not a sexual abuse case. It's a physical abuse case. It's a lot different because physical abuse cases, you have concrete evidence that you can corroborate, pictures of bruises, x-rays with broken arms and broken legs. Sexual assault cases, when I do those two, they're real difficult because there are no injuries. So then you can call the child a liar over and over again. But this is different. He talked about coaching and suggestibility, and I thought it was just disrespectful. You can coach a dog. Millie is not a dog. She's a living, breathing human being. How dare you compare her to a dog? It's not difficult to coach 4-year-olds. I hope somebody who's on here, my husband coaches soccer for my son, trying to gather up 4-year-olds and trying to get them to do one thing and then trying to get them to remember a lie since 2015? It's impossible. The only reason she remembered those things is because that's what she experienced. And he told you, he never said anything about finding it. And then they talked about, oh, the people that was there to interview, the way it was done, it was horrible. That's not how you should do a forensic. But what did he tell you as well as Ms. Whitmore? It doesn't matter. You can have a great interview and not have any disclosure. You can have a bad interview and have disclosure. So it's really just a distraction. Cooperation is an important factor. We have cooperation all over this case. Chris Berry, my trial partner talked about it. I'm trying not to talk about it too long, but it's just too entertaining not to. He don't have all the facts. You bring a medical doctor in here, you have not told him all the facts. You haven't told him about the various stories about the leg being broken. And then he told me, he talked from both sides of his mouth. Oh, you can't tell pattern injuries. He can't tell you that was from a belt. But then he go, oh, yes, those look like ladder marks. Oh, yes, those look like knuckle marks. They do. I agree with him on that. A little bit true, because she was punching that baby in the back. And she never said she was punching her in the back, because he's talking about what she told the police. Pat, 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 pat. That's not going to give you the knuckle bruises that baby had. Oh, the gripping around the waist, those are fingertips. You'll have the pictures back there. They don't look like no fingers. Loops. Linear marks. The inner thigh, oh, she was holding her this way, and she never said anything to the police about holding her in between her legs. See, they want to discredit that, because what did Dr. Messer tell you? And when he tried to explain and show, she took that picture down real fast. And then she didn't even say that. She said, I pinned her legs down and her arms down. And you need to listen to her statement. You hear, those are her words. They want to start making things to conform to the evidence. And I think the most disgraceful thing, he wanted to fool y'all and say, y'all don't have common sense and y'all don't know what a scar looked like. That's an impression from a diaper after she was dead? That didn't even medically and scientifically make sense. Her skin is a totally different color. If you're going to bring somebody in here to give you this information, this important information, I think it should be somebody credible, somebody respectable, somebody worthy of belief, not somebody who's just going to tell you whatever they need to tell you in order to get a paycheck. And they talked about Laila's arm being a non-union fraction, but Millie, they want to forget about Millie's broken arm. They don't want to talk about the ears, impetigo. My trial partner talked about that. It's just foolishness and lies. But he did say, you can't change, you can't tell the age scientifically, to a scientific certainty. But what did he also tell you? But you can tell. And I think Mr. Chase did a really good job because you testified to that before. Oh yes, those yellow hues. And you will see those yellow hues in those pictures that you will have back there with you. So we know that there were all injuries. And the Heimlich maneuver. He says, oh yes, I know it was a Heimlich, but he told you, you don't die from the Heimlich. She's just an anomaly, unless I'm part. And then he talks about the chunk of chicken. It's not a chunk of chicken in that scene. And she doesn't even describe a chunk of chicken. She says that it was crumbs that came out. And she says, oh, they want you to believe Dr. Duxbury. Dr. Duxbury, he came here and everything he says must be the truth. Well, they brought Dr. Sperry in here and they want you to believe him, who had early retirement. Forced out because you was breaking the law. They let you go. Keep your head held high rather than arrest you and fire you. And she wants you to believe that Dr. Duxbury is lying about who filled out this form. Why does he have to do that? Maybe. Well, that's what Dr. Sperry wants y'all to believe, that all of these medical anomalies is what caused this child's death. That's what they want you to believe. That's not reasonable doubt. It's foolishness. And he comes in here and he wants to explain all of the injuries after they've sat here for 2 weeks and listened to the state's evidence, and then they want to tell you that it conforms to the injuries. How much he said he was making? $7,500. Now they want to insinuate that Dr. Messner was getting paid, that Dr. Darasol was getting paid. They were on salary. He's getting expert witness testimony fees. It's a big difference. And you heard, he tells whatever for whoever when they pay him. He's a liar for hire. And he relied on the lies of the defendant to make his determination. She continually said nothing came out. She never said anything about a hunk of chicken. She never told the police to collect it. Those are all lies. You don't listen to her statement. And he said he never considered suicide. He never considered homicide? With a baby with injuries from head to toe? That's unworthy of any consideration. And she wants us to bring somebody in here to rebut that. I don't rebut the foolishness. You had 2 weeks of good, reliable, credible evidence. I don't need to back it up. You already got it. Because what did Dr. Darasol tell you? Improbable, illogical, and unreasonable. She already told you all of the lies that he was coming in here to tell what they were. Then they talked about counseling. So many
So now he's done the room that I'm not going to say that he was going to do some type of counseling or something. So I'm going to do that. So I'm sure he's still with them.
Yeah, it's private Lord, yeah, right, counseling, they're all trying to say counseling.
Yeah, we'll use in that one, but she's like, I don't know.
Yeah.
I mean, but we'll also be honest, that was having these counselors that do like, she just don't know. She's been really interested, especially because she.
just lies like in general. Because what did the pathways tell you? They were not in counseling. They were too young. Then we got the daycare lie. Josie told them they ain't not in daycare. We got denied, but she continues to say they were in daycare. She told Michelle Hall those injuries she saw in the 15 came from daycare. She told Peggy Bates and Kim Smith the injuries on her face came from daycare. She told Samantha White the injuries came from daycare on her wrist. She told then on October the 6th, she told Samantha they're no longer in daycare. But lo and behold, on October the 13th, to the doctor, she goes to daycare twice a week. She tells the people at the health department they're being fed at the daycare twice a week. Ola Academy, Bethany Baptist. One of my favorite movies is Unusual Suspects. I hope somebody's ever seen it before. When he's sitting in that office and he starts looking at different things and just start naming them, because that's what he sees. Oh, I'm leaving home, what do I see? Old Academy. Oh, what do I see? Bethany Baptist. She thinks it's a movie. But what do we know? They never attended either one of those. And then when we shut that down, now they go to Turning Point. Then we shut that down. They don't even have daycare. And it was a Wednesday when she sent Tessa those messages. And then she goes back in November telling the police.
Now, you're going to say you have school on certain days. Another thing, take you out of the home, and if so, you have to show a window, or you have another way of, caring for them when you have to go to school, or if you're out of home every day, I don't know. I'm clear if you leave for, have other business on those other days, or what.
I do not. I'm always out about it. The girls are always with me if I'm in the house. It was always be, I've been working sure meetings, the girls are intended to be, the girls are meetings, the girls are intended to be.
So you go to school on Tuesday, Thursday.
Yeah.
And when you do that, and Joseph, he works nights or days?
He was overnight.
Overnight. So is your school during the day or evening time?
It's during the daytime.
Okay. So if you go to school on Tuesday and Thursday, did y'all have another caregiver to watch the show, or just watching? And then, say the other days, are you almost lawful not. Because kids like you have to go do other things and they're letting someone else here.
No, I mean, no, they, like, whenever I'm at home or if I was going somewhere, generally they were pretty much with me. I mean, the only times they weren't with me, they had something by visitations with their grandmother.
She told the police they don't go to daycare, but yet still, she's texting on August the 12th, saying that the daycare called, she gotta go pick her up, and this is at 2 o'clock in the afternoon, not 7 o'clock on that Wednesday, because see, they're still trying to cover that lie. Oh, they do have stuff on Wednesday. We talking about Wednesday, the second Wednesday of that month, at 2 o'clock in the afternoon, when she's texting or Facebook messaging Tessa, talking about they're in daycare. Just lies. She told her friend Chelsea it's mosquito bites. Then we talk about these hospital visits that they never went on. No Medicaid records of it, and you have it back there with them. Just manufacturing lies. You have the pictures back there. She sends those messages to Tessa on August the 12th saying, we at the doctor's office. When you get back there, you'll see, because you can't really see up here, that picture was taken on June 13th. Just manufacturing lies. She's sending messages to Alexa Battle, talking about she fell down the stairs on August the 12th, not that she went to the hospital for an IV. And what does Alexis Battle also tell you? That she was getting spankings. She saw her give her a spanking. She said, I never spanked you. Another lie, they sent this picture to Peggy talking about, oh, right before bedtime on October the 13th, the picture was taken in September. Just lie about the little things just to be lying. And we talked about all the lies that they told about her broken leg, lie after lie after lie. You know the difference between a beam and a bar, you were lost in it. We talked about Dr. Duxbury. She wrote that history of abuse, and it was, because she was abusing these girls. And she told Carpenter that it was on the 18th. She told Miss Carr, everybody gets a different version, a different story. But she don't tell the people at Gym Tech. First of all, she registered as Millie Rosenbaum. That's not her name. No pictures of Laila at daycare, at gymnastics, but then all of a sudden, oh, it was a trial class. There's unsupervised play. Those people told you no way, no how. And what the teacher told you that was involved, she was crying, she only did the floor exercises, and she was busy telling me about Tessa being on drugs. And you never reported to the staff or anybody. And then she tells Miss McKee a huge lie. I'm running out of time, so I'm past that. But you need to listen to it. She tells her that they was getting fed their feces, they were having water thrown on them. She doesn't say anything about that to the police when they asked her about the history of the kids, because there was no physical abuse. And the biggest lie of all.
Okay, I'm gonna give you a search to go ahead and do it. She's just choking on the nail?
No.
Because she was never choking. She was an MP. She knew how to give CPR. These injuries are not consistent. We have old injuries all over this kid's body. And what did the EMT tell you? Not Millie. The EMT told me she was dead when I got there. What did the doctors tell you? She was dead when she got to the hospital. I sent to you, she had been dead for a while. I don't know how long it took her to call for help. She knows how it works. That's why she didn't go to Edison when Duxbury told her to. She started to alienate the family. No pictures. Because what does Tessa ask me? Send me some pictures of the girls. The last ones, all you see is their face, not their bodies. These girls had more injuries than anybody probably has seen in their entire lives. From the point that they started going with these defendants, in general, bruises, burns on their hands, injuries to their leg, injuries to their face, falling down the stairs, never falling down the stairs. They come back 4 days later, they hurt at daycare that doesn't exist. Oh, they hurt at the daycare again with the wrist, falling on toys. So, I mean, they're just falling and breaking things in 3.5 months, and they've been fine all this time. Being a short period of time, but they've been fine. 90 injuries on Laila's body, 15 on Millie's, 3 broken bones on Laila. She had more bones than however many years she had been on this earth. 1 on Millie. And Laila was always sick. Yes, she was sick because she was healing from that old liver laceration from one of those punches on knees and stomach. Because what they tell you, she wouldn't be eating, she would be lethargic. And what did Sarah McKee tell me? She was just very unusual. She just hung out on the bed. She didn't jump around, try to get on anything or anything like that when she was at the gym because she was hurting. Because her body was trying to heal from those old abdominal injuries. And the funny thing about abuse, it escalates. It starts small and then it gets big. And that's why we're here, because it ended in Laila's death. Injuries by everybody. But all of these people must be liars. They talk about Michelle Hall, but she took her to Michelle Hall and said, look at her face. So they want to bring you pictures from this, from the day before or the day after. She said she fell down and she had injuries. It's in her statement. Alexis Battle, I guess she's lying too. It's just despicable people they want to call liars. And they want to bring in, oh, she was playing on the trampoline at Miss Hall house. Miss Hall was on the stand. Nobody ever asked her, were they playing on the trampoline at your house? Did they get hurt? No, they didn't want to ask her that because she was going to tell the truth. But they bring someone else in here to tell you that they was at Miss Hall house playing on the trampoline. I guess Miss Evans Battle was lying too because she told y'all about an injury that she saw that came from a bathtub. And then she's falling down the stairs, but she has a gate. They brought you a picture of a gate. They're not falling downstairs, they're being beaten over and over again. No one observed any injuries because there weren't any at the time when they were seen. They were only in the care, according to them, for the last 2 weeks of their lives. What did Millie tell you? They put a sleeve on my elbow. Nightstick. That's horrific to think about. But she has a wrap on her arm. And this, you'll see the blood that we talked about in DNA. That couch where Laila laid on, where the icy hot is in the windowsill, had Laila's blood on it. That's where she laid. Just on and on injuries. And then they talked about Mesmer. Well, Mesmer saw these, he's an advocate for children. And don't believe him when he comes in here and tells you that those marks are belts. Because Darosol didn't say it. Mesmer deals with abused kids. Darosol deals with dead kids. That's why he's able to tell you what those are, what those patterns look like, about those girls' hairs being pulled out. And then Darosol can come in here and tell you what could have been the mechanism that caused the injuries that killed them. Hits, punch, knees, the force, and pain. And we talked about her leg being broken, her failure to go in with provider shopping. They was arguing about a form. She was worried about Medicaid. Lies. No, she was worried when she went to Evanston that they was going to figure out that she had been abusing this child and what she was saying was not true. Failure to get treatment. Healing fractures that they will now call non-human fractures. No, they were non-human. They were non-healing fractures or fractures that were having to heal themselves because they didn't get treatment. I told you he's here. What did Chelsea Herbert show you? After the arrest, he called me and said, hey, what about that injury that they showed up with back to the house and Jennifer said it happened at your house? What did Chelsea Herbert tell you? That's a lie. And they talk about Facebook postings. What she had posted all those positive things about Jennifer. So why she in here lying? She's not. She's telling you the truth. He knew what was going on and didn't do anything. He put icy hot on it. And we know Billy telling the truth because she says it gets hot and then it gets cold. How does she know that unless he's been soothing those bruises that his wife has been inflicting? Standing by doing nothing. And what does mama tell you? He would tell about abuse if just Jen and not him. That's why he didn't tell his mama. That tells you right there. He was inflicting those spankings just like Miss Lambert told you Billy said he was. To kill Laila. I would infer he tells her, if you keep doing that, you're going to kill Laila. And unfortunately, she did. She asked the 12-year-old little girl and Natalie Harrington, well, did you call the police? Did you call defects? When did Joseph pick up a phone? When did he call the police? No, he just continues to sit there in silence. He had a duty, and he failed her. And just to be clear, ladies and gentlemen, when I talk about...
Let's set up before we start.
To be clear, ladies and gentlemen, I'm not talking about him not saying nothing today, not saying nothing doing this. I'm talking about in 2015 when he didn't do anything. That's what I'm talking about. Because he has a right. He don't have to get up here and say anything. He has that right. Millie School, I hope y'all paid attention. Miss Andrews had to come all the way over here so that baby didn't have to keep looking over there again with terror in her eyes. That speaks volumes. She's been consistent since 2015. And I told you, domestic violence victims, grown people, get conflicted. Tell them to lie about it. I think the most poignant thing that she said, there are bad and good people in this world, and I can't tell the difference. That breaks my heart because of them. She doesn't know who's good and she doesn't know who's bad. And that was at 7 years old, not at 4 like they want to lie and tell you. But what were they doing? Taking on trips, giving them clothes. That's what abusers do. They behave in public. I'll submit to you, you got a 2-year-old or 4-year-old that can sit at board meetings. That's because you just got to give them that look. Move if you want to. She don't have to beat them in public. And who beats their kids in public? Oh, I'm sorry, someone else does. But let me tell you, they weren't beat, they weren't spanked, they were tortured and brutalized. But when she got safe with the Lambert, she told. And then she was telling, oh, Miss Brown influenced her. Miss Brown said in 2016 is when Millie told her what happened. At no point have you heard that there were any signs of coaching. She's able to correct them, and she's able to give details, which are very important, those contextual details. Spanked for not getting dressed quickly enough. And what do we know about this case? She was trying to get to her beating. She needed to go. Laila probably was not getting up and doing what she needed to do as quickly as she needed to do. And she paid for it, and she paid for it dearly. Spanked for not wiping good. She's 4. And if you tell somebody, you're going to get it worse. Icy hot, she knows how it smells, she knows how it feels. It smells like old people. Those are contextual details. Ms. Mull is right. The devil is in the details. And this baby got way too many details. She said they dragged us down by my arm. Dragging Laila down the stairs. Dragging her down the stairs. And what do they both have? Broken arms. An orange elbow sleeve. Not just an elbow sleeve, an orange one. Those are details. Punished for sleeping in the car. And what does Ms. Rosenbaum tell you? Mary Rosenbaum. Every parent welcomes that. That's so important. Because that's the truth. So what parent, what great-grandmother would think, let me tell this child to tell people that she got spankings when she went to sleep in the car? It wouldn't come to your mind because it does not make sense. The reason you know that's true, because it doesn't make sense for an adult to feed that to a child. Well, he's getting that. She had to eat vomit. Who tells a child that? No adult is going to say, tell them when you eat mashed potatoes, you throw it up, and then you have to eat it. Because it's disgusting. Ms. Banks didn't tell her that stuff. That's stuff that she experienced. She fell from the gymnastics bar. You got to look at whether or not what she's saying is consistent with her injuries. Maybe she did fall from the bar and she hit her elbow, but we know that didn't break her leg, her arm, because it wouldn't generate enough force. And we know Laila didn't break her leg at gymnastics. But see, she's able to tell you, and what did she say? Miss Jennifer told me Laila broke her leg at gymnastics. Miss Jennifer told me that Laila choked on chicken. Not these are things that she experienced. So what she's telling you are things she's experienced and not what she's being told by anyone. And she's able to correct people when they start to try to tell her something differently. Those are all signs of abuse. And that's what Millie and Laila experienced throughout the time that they were with the Rosenbaums. And let me tell you, that picture that they showed you of them sleeping in the car, and I submit there may be videos too, that was evidence. You sleeping, I'm gonna show you this, like you do dogs. When they pee somewhere, you take it to them. That's what she was doing. You went to sleep. You gonna get your butt towed up today. That's what that was about. Not little cute little pictures they sleeping in the car. All of the injuries are consistent with what Willie says. Laila's stomach, her intestines being bruised, her pancreas being split in half, all consistent with being knee, arms being yanked, patterns from belts. All the things that Millie described. And let me tell you about that chicken that they claimed was in the sink. And you don't have the pictures back there. There's no chicken in that sink, not one chunk. So she never told him to collect it because it wasn't there, because it was never in her throat, which is real important. If you're choking, somebody should find it somewhere. It should be on the floor, it should be in the sink, it should be in your body, nothing, nowhere. And that high chair was real clean, ladies and gentlemen. A 2-year-old eating, ain't nothing in there. She's afraid on the 911 call. She's panicked. She is because she just killed a child. No intent. When you kick, when you punch, when you knee, you have intent. She had time to go get a blue towel. Remember, who has time to go get a blue towel when you're in such a pain and you're trying to beat this child down before you try? She didn't do any of that. All actions of a murderer. The injuries are not consistent with the description she gives for the Heimlich. See, Ms. Mull wants to get up here and say, oh, it was thrust. She didn't say thrust up like Ms. Mull was demonstrating. She said, I put her over the sink and I was patting her on the back. Then why are all her insides all torn up? She says, I dropped her on the floor. See, she's trying to cover for them injuries in her head. Oh, yeah, now I remember she fell down the stairs, so there may be some injuries on her back. Because see, she knew something. Somebody was going to see something. So her mind is tickling and is trying to figure out what can I tell them. She's trying to explain away the injuries that she knows that they're going to see. But it's really important in that interview when they want to start talking about those other injuries, the inner thigh, the vaginal area, the butt. We're not here to talk about that. But we are today. We've been talking about it for the last 3 weeks. And you have all the evidence to know that those injuries are not consistent with a layperson getting Heimlich. And then we got to add Millie. How do you explain Millie having injuries on the 17th? You weren't giving her a Heimlich? No, this is all consistent with abuse over the course of time that you've been with them.
I remember calling after that I was over here and being over the window because it was 14 miles and I'm like, oh, how are we doing it? Well, the thing that I'm doing yesterday is doing now. The doctor said,
She laughs about that, ladies and gentlemen. She's talking to these kids' mother, their mother, and telling them, good thing I have not killed them yet. First of all, if you're not doing anything that would kill them, why would you make that statement? Why would you make that statement? The guilty conscience of the mind, because you know what you're doing. To their mother who has not seen them in months, who their mother is struggling emotionally with her own guilt about not having her kids. Your comment to her is, good thing I haven't killed them yet, knowing fully well that you are beating and brutalizing these children. It's heartless. It's inhumane. It's cruel. And it's evil. Now, ladies and gentlemen, we talked a lot about these defendants. I want to talk to you, like Mr. Chase said, about why we're here. In the opening statements, the defense talked about, oh, they've lost everything. Their lives have been destroyed. They want to talk about all their milestones. Well, let's talk about Millie. What's been lost for her? Her innocence. She knows things at an age that no child should have to know those things. No adult should have to know the things that she knows. No adult should have to endure the things that she had to endure. And she was 7 years old when she came in front of us. Cute as a button. But I want you to remember she was 4 when she was being beaten and dragged and tortured by these defendants. But she's so resilient. That's what I love about kids. They amaze me. This is a hard job to do. But to watch these babies be able to walk through that with their heads held up high, with a smile on their face. But her innocence is gone. Her life will never be what it could have been. She's a completely and totally different person because of what they did to her. But you know what, ladies and gentlemen, she's lucky. Those physical injuries she had, they have healed. Now that emotional trauma, it'll probably be with her for a lifetime. But what's good for her is she has an amazing mother who was there to support her, to care for her. A single woman who has taken on 3 kids who have come from traumatic backgrounds. And she has an amazing village of support. And I just hope for Millie that this is just a chapter that she can close and move forward in a much better way. Laila's not so lucky.
Wait. Where you going? Bye-bye. Bye-bye.
2 years old. You want to talk about loss? She lost her life because you are evil, cruel. How can you look at a 2-year-old and pick up your foot, your hand, a belt, and inflict the kind of injuries and pain that you did? A nightstick injury is what they call that breaks her arm. A nightstick injury. And you didn't even go get it fixed. Despicable. She wanted to come in here and say, oh, they went to graduations, they went to weddings. Let me tell you something. There are so many milestones in Laila's life that she will never get to see. My son turned 13 years old today. That's a milestone. I'm here with y'all today. But it's a milestone. He is getting to be a teenager. Last week would have been Laila's 6th birthday. School supplies are out. She would have been getting ready to have her first day at school. But because of them, a milestone she will not get. She won't get no more birthdays. She won't get no more graduations. She won't get no weddings. She won't get no child. Because of them. And they want to talk about what they've lost? Unconscionable. All Tessa Daniels has is that last phone call with her baby. And for what? Like Mr. Chase told you, I can't tell you why. Because nobody can explain why somebody would put their foot up, their knee up to a baby and do what they did. And good thing the law recognizes that and we don't have to tell you why. But I'll tell you why, ladies and gentlemen. Evil. Egregious. The acts were egregious. Vile, distasteful, and sickening. Immoral, wicked, dishonorable, and depraved. And they're liars, deceivers, predicators, like they wanted to call Millie. That's what evil represents. I know you all don't get to do it very often, but unfortunately in the job that I do, I sit in a room with evil every day. And for the last 3 weeks, we have been sitting in a room with some of the most evil people I have ever come across in my 20 years of prosecution. A baby. And then you have the nerve to get in here and continue to lie after lie after lie after lie. They should be ashamed. But I tell you, ladies and gentlemen, you have the honor and the duty to do what nobody else has been able to do. I love this quote. Evil prevails when good people do nothing. I ask that you not let evil prevail today. I ask that you hold them accountable for each and every county that indicted, all 49 of them. Because that's what they deserve. That's what Laila deserves. That's what Millie deserves. I beg upon you. I beg you. Give them the justice that they deserve. Speak the truth. Guilty.
All right, thank you, Michelle. Ladies and gentlemen, this is the time when the court gives you its instructions, what the law is applicable to the case. I'd like to keep you here a little longer today than I ordinarily do, so that I can make sure that you hear this immediately after the closing arguments, and that you have all of it together and you can begin your deliberations on Monday morning when you return at 9 o'clock. If there's anybody that needs to make a quick phone call to somebody to let them know that they'll be a little late, then I think what I'm going to do is give you 10 minutes or so to do that, to make those calls. I'll let them know that you should be released from here by 6:30. All right, thank you.
Honorable Brian J. Merrill presiding.
All right, good afternoon, everyone. Thank you, Steve. It's come to my attention that the jury has reached a verdict. Is that correct?
That's our understanding, Your Honor.
All right. If we could please have the jury step into the jury box. Okay. Ladies and gentlemen, it's come to my attention that you have reached a verdict in this case. Is that correct?
It is.
Are you the foreperson?
I am.
Would you please stand and state your name?
My name is Jody Thunderbird.
Mr. Thunderbird, is the verdict form filled out?
It is.
And is it signed and dated by you?
It is.
All right. Would you please publish your verdict to the court? In other words, read it.
For count 1, Malice murder, we the jury find the defendant, Jennifer Michelle Rosenbaum, not guilty. Count 2, felony murder, we the jury find the defendant, Jennifer Michelle Rosenbaum, not guilty. Count 3, aggravated assault, we the jury find the defendant, Jennifer Michelle Rosenbaum, guilty. Count 4, felony murder, we the jury find the defendant, Jennifer Michelle Rosenbaum, not guilty. Count 5, cruelty to children in the first degree, we the jury find the defendant, Jennifer Michelle Rosenbaum, guilty. Count 6, felony murder, we the jury find the defendant, Jennifer Michelle Rosenbaum, guilty. Count 7, aggravated battery, we the jury find the defendant, Jennifer Michelle Rosenbaum, guilty. Count 8, murder in the second degree, we the jury find the defendant, Joseph Michael Rosenbaum, guilty. Count 9, cruelty to children in the second degree, we the jury find the defendant, Joseph Michael Rosenbaum, guilty. Count 10, aggravated assault, we the jury find the defendant, Jennifer Michelle Rosenbaum, guilty. Count 11, cruelty to children in the first degree, we the jury find the defendant, Jennifer Michelle Rosenbaum, guilty. Count 12, aggravated assault, we the jury find the defendant, Jennifer Michelle Rosenbaum, guilty. We the jury find the defendant, Joseph Michael Rosenbaum, guilty. Count 13, cruelty to children in the first degree, we the jury find the defendant, Jennifer Michelle Rosenbaum, guilty. We the jury find the defendant, Joseph Michael Rosenbaum, guilty. Count 14, aggravated assault, we the jury find the defendant, Jennifer Michelle Rosenbaum, guilty. We the jury find the defendant, Joseph Michael Rosenbaum, guilty. Count 15, cruelty to children in the first degree, we the jury find the defendant, Jennifer Michelle Rosenbaum, guilty. We the jury find the defendant, Joseph Michael Rosenbaum, guilty. Count 16, aggravated assault, we the jury find the defendant, Jennifer Michelle Rosenbaum, guilty. Count 17, cruelty to children in the first degree, we the jury find the defendant, Jennifer Michelle Rosenbaum, guilty. Count 18, aggravated assault, we the jury find the defendant, Jennifer Michelle Rosenbaum, guilty. We the jury find the defendant, Joseph Michael Rosenbaum, guilty. Count 19, cruelty to children in the first degree, we the jury find the defendant, Jennifer Michelle Rosenbaum, guilty. We the jury find the defendant, Joseph Michael Rosenbaum, guilty. Count 20, aggravated assault, we the jury find the defendant, Jennifer Michelle Rosenbaum, guilty. Count 21, cruelty to children in the first degree, we the jury find the defendant, Jennifer Michelle Rosenbaum, guilty. Count 22, aggravated assault, we the jury find the defendant, Jennifer Michelle Rosenbaum, guilty. We the jury find the defendant, Joseph Michael Rosenbaum, guilty. Count 23, cruelty to children in the first degree, we the jury find the defendant, Jennifer Michelle Rosenbaum, guilty. We the jury find the defendant, Joseph Michael Rosenbaum, guilty. Count 24, aggravated assault, we the jury find the defendant, Jennifer Michelle Rosenbaum, guilty. Count 25, cruelty to children in the first degree, we the jury find the defendant, Jennifer Michelle Rosenbaum, guilty. Count 26, aggravated assault, we the jury find the defendant, Jennifer Michelle Rosenbaum, guilty. We the jury find the defendant, Joseph Michael Rosenbaum, guilty. Count 27, cruelty to children in the first degree,
We the jury find the defendant, Jennifer Michelle Rosenbaum, guilty. We the jury find the defendant, Joseph Michael Rosenbaum, guilty. Count 28, aggravated assault. We the jury find the defendant, Jennifer Michelle Rosenbaum, guilty. Count 29, cruelty to children in the first degree. We the jury find the defendant, Jennifer Michelle Rosenbaum, guilty. Count 30, aggravated assault. We the jury find the defendant, Jennifer Michelle Rosenbaum, guilty. We the jury find the defendant, Joseph Michael Rosenbaum, guilty. Count 31, cruelty to children in the first degree. We the jury find the defendant, Jennifer Michelle Rosenbaum, guilty. We the jury find the defendant, Joseph Michael Rosenbaum, guilty. Count 32, aggravated assault. We the jury find the defendant, Jennifer Michelle Rosenbaum, guilty. We the jury find the defendant, Joseph Michael Rosenbaum, not guilty. Count 33, cruelty to children in the first degree. We the jury find the defendant, Jennifer Michelle Rosenbaum, guilty. We the jury find the defendant, Joseph Michael Rosenbaum, not guilty. Count 34, cruelty to children in the first degree. We the jury find the defendant, Jennifer Michelle Rosenbaum, guilty. We the jury find the defendant, Joseph Michael Rosenbaum, not guilty. Count 35, aggravated battery. We the jury find the defendant, Jennifer Michelle Rosenbaum, guilty. We the jury find the defendant, Joseph Michael Rosenbaum, not guilty. Count 36, aggravated assault. We the jury find the defendant, Jennifer Michelle Rosenbaum, guilty. We the jury find the defendant, Joseph Michael Rosenbaum, not guilty. Count 37, cruelty to children in the first degree. We the jury find the defendant, Jennifer Michelle Rosenbaum, guilty. We the jury find the defendant, Joseph Michael Rosenbaum, not guilty. Count 38, cruelty to children in the first degree. We the jury find the defendant, Jennifer Michelle Rosenbaum, guilty. We the jury find the defendant, Joseph Michael Rosenbaum, not guilty. Count 39, aggravated battery. We the jury find the defendant, Jennifer Michelle Rosenbaum, guilty. We the jury find the defendant, Joseph Michael Rosenbaum, not guilty. Count 40, cruelty to children in the first degree. We the jury find the defendant, Jennifer Michelle Rosenbaum, guilty. We the jury find the defendant, Joseph Michael Rosenbaum, not guilty. Count 41, aggravated battery. We the jury find the defendant, Jennifer Michelle Rosenbaum, guilty. We the jury find the defendant, Joseph Michael Rosenbaum, not guilty. Count 42, cruelty to children in the first degree. We the jury find the defendant, Jennifer Michelle Rosenbaum, guilty. We the jury find the defendant, Joseph Michael Rosenbaum, guilty. Count 43, aggravated battery. We the jury find the defendant, Jennifer Michelle Rosenbaum, guilty. We the jury find the defendant, Joseph Michael Rosenbaum, guilty. Count 44, aggravated assault. We the jury find the defendant, Jennifer Michelle Rosenbaum, guilty. We the jury find the defendant, Joseph Michael Rosenbaum, guilty. Count 45, cruelty to children in the first degree. We the jury find the defendant, Jennifer Michelle Rosenbaum, guilty. We the jury find the defendant, Joseph Michael Rosenbaum, guilty. Count 46, aggravated assault. We the jury find the defendant, Jennifer Michelle Rosenbaum, guilty. We the jury find the defendant, Joseph Michael Rosenbaum, guilty. Count 47, cruelty to children in the first degree. We the jury find the defendant, Jennifer Michelle Rosenbaum, guilty. We the jury find the defendant, Joseph Michael Rosenbaum, guilty. Count 48, cruelty to children in the second degree. We the jury find the defendant, Jennifer Michelle Rosenbaum, guilty. We the jury find the defendant, Joseph Michael Rosenbaum, guilty. Count 49, cruelty to children in the second degree. We the jury find the defendant, Jennifer Michelle Rosenbaum, guilty. We the jury find the defendant, Joseph Michael Rosenbaum, guilty. Dated this first day of August 2019.
All right, thank you, sir. Would you please pass the verdict form to the sheriff's deputy, who will give it to the parties so they can inspect it as before. All right. Ladies and gentlemen.
Yeah, I remember saying that at the beginning. It must be really weird for the Rosenbaums. You know, if you have any sort of, you know, pity of any kind at all, it'd be like, you know, these are two people that are married. I don't know what their relationship was like, but they're sitting there in this trial knowing that they'll never see each other physically or really ever again, you know. But maybe they should have thought of that before they beat a little child to death. Yeah. But at the same time, you can just sort of think of it just as a human. Like if you're married to somebody and you did something horrible like that, you probably even regret the hell out of it later, but you're sitting there in trial next to somebody you're never really going to get to see, you know? Yeah, I said that, Danielle. Way to go to repeat exactly what I said.
The both of the parties, both the state and the defense, agreed. Have any objection to the form of the verdict? Not conceded. All right. Ladies and gentlemen, there has been a request from the defense of the jury before. What this means is that I have to ask each of you a few questions. And let me start with our foreperson, as I'll work my way across the top, and then across the bottom, and then back into the front. Sir, please stand again and state your name.
Jody Funderburg.
Mr. Funderburg, the verdict that you published here at open court, was that your verdict when it was reached in the jury room?
Yes, sir, it is.
Was it freely and voluntarily made by you?
Yes, sir, it was.
Is this verdict still your verdict?
Yes, sir, it is.
All right, thank you. Please proceed. Sir, please stand and state your name.
James Brown.
Mr. Brown, was the verdict that was published in open court, was that your verdict when it was reached in the jury room?
Yes, sir.
Was it freely and voluntarily made by you?
Yes, sir.
Is this verdict still your verdict?
Yes, sir.
Thank you. Please proceed. Ma'am, please stand and state your name.
Vicky Francis?
Ms. Francis, you've heard this verdict that was published in open court, true?
Yes, sir.
Was that your verdict when it was reached in the jury room?
Yes, sir.
Was it freely and voluntarily made by you?
Yes, sir.
Is the verdict that was published here at open court still your verdict?
Yes, sir.
Thank you, ma'am. Please proceed.
Actually, you.
Ms. Pugh, you've heard the verdict as it was published by your foreperson in open court, true?
Yes, sir.
Was that your verdict when it was reached in the jury room?
Yes, sir.
Was it freely and voluntarily made by you?
Yes, sir.
Is the verdict that was announced in open court still your verdict?
Yes, sir. Proper.
Ms. Crawford, you heard the verdict that was published here in open court, true? And was that your verdict when it was reached in the jury room?
Yes, sir.
Was it freely and voluntarily made by you?
Yes, sir.
And is that verdict still your verdict?
Yes.
Thank you.
Michaela Kettle?
Ms. Kettle, you heard the verdict that was announced in open court. Was that your verdict when it was reached in the jury room?
Yes.
Was it freely and voluntarily made by you?
Yes.
Is this verdict still your verdict?
Yes.
Okay, please proceed. Yes, ma'am. Ma'am, will you please stand and state your name?
Laura Walker.
Your last name again, please.
Walker.
Welkers. Ms. Welkers, you've heard the verdict that was published here in open court, true?
Yes.
Was that your verdict when it was reached in the jury room?
Yes.
Was it freely and voluntarily made by you?
Yes.
Is the verdict as published here in open court still your verdict?
Yes.
Thank you. Please proceed. Sir.
Dennis Dean.
Mr. Dane, you've heard the verdict that was published here in open court, true?
Yes.
Was that your verdict when it was reached in the jury room?
Yes.
Was it freely and voluntarily made by you? Is the verdict as published still your verdict?
Yes.
Thank you. Please proceed.
Clarence Davis.
Mr. Davis, you've heard the verdict that was published here in open court.
Yes.
Was that your verdict when it was reached in the jury room?
Yes, sir.
Was it freely and voluntarily made by you?
Yes, sir.
Is that verdict as published in open court still your verdict?
Yes, sir.
Thank you. Please proceed.
William McClenny.
Mr. McElhenney, you've heard the verdict that was published in open court.
Yes.
Was that your verdict when it was reached in the jury room?
Yes.
Was it freely and voluntarily made by you?
Yes.
Is that verdict that was published in open court still your verdict?
Yes.
Thank you. Please proceed. Mr. Harris. Mr. Harris, you've heard the verdict that was published here in open court. Was that your verdict when it was reached in the jury room? Was it freely and voluntarily made by you? And is the verdict that's published here in open court still your verdict?
Yes.
Thank you. Please proceed.
Fernandez Dennis.
Yes. You've heard the verdict that was published here in open court.
Yes.
Was that your verdict when it was reached in the jury room?
Yes.
Was it freely and voluntarily made by you?
Yes.
Is the verdict as published here in open court still your verdict?
Yes.
All right, thank you. Please proceed. All right. Is there anything else before this jury is dismissed? All right. Ladies and gentlemen, your service in this case is concluded. We Thank you for your time and your attention throughout the course of this case and for your service. At this time, you're going to be excused and requested sheriff's deputy and brought safely to your cars, and we'll be sure that you make your way safely home. Thank you again for your time, your attention, and your service, and you are excused. Okay, go ahead. Please be seated. Okay. All right, that's everybody. I'm ready to proceed directly to sentencing. Is the state ready to proceed?
Yes, Your Honor.
That's right.
I'm going to ask for sentencing hearing at a later date, so we have an opportunity to bring in witnesses.
I'm going to go ahead and deny the request for sentencing at a later date and proceed directly to sentencing at this time. Is there any evidence from the state?
Yes, Judge.
Can you make a phone call to see about getting people up here to speak to the court on sentencing matters? There are people who wanted to speak on this issue if this came up. And we just like a brief moment to call them.
Judge, I actually went out to get some of the statements and been waiting to the jurors clear the hall. I believe I can let you.
Why don't we take then just a 10-minute recess to give you an opportunity to get your witnesses together, and also to give Ms. Small an opportunity to reach out to her folks to the extent she's able to get them here in the next few minutes. The reason that we're not going this is because, of course, this is something that the parties could have planned for should this eventuality occur. Thank you.
Oh, sorry.
Remain seated, come to order.
Okay, we're back. I'll hear the same statement.
Yes, Judge.
Right there, please.
Okay, Judge.
Good evening. I'm here to speak on behalf of my family. Throughout this entire trial, the defense has tried to paint a pretty picture for you all, so I would like to do the same. It's July 18th, and it's a celebration. My niece, Laila Marie Daniel, is turning 6 years old today. While she's outside playing with her sisters and her friends she made this year in kindergarten, we are prepping her birthday cake with 6 candles. She's surrounded by gifts and decorations, but most importantly, she's surrounded by love. I picture the happy, smiling, and healthy little girl so many people knew her to be. And it breaks my heart, bringing tears to my eyes every time I think of how she would look now and how happy she would be. The truth of it all, exactly 2 weeks ago today, it was July 18th, 2019, and instead of attending Laila's 6th birthday, I was here with you all listening to the brutal details that her and her sister went through while living with the Rosenbaums. We've had to sit through and witness photos of an innocent 2-year-old beaten and broken little body, and listen to the horror that ended up in her murder impacting my family. To Millie and Laila, I was, and I still am, their Aunt Cat. And during this trial, our side of the family's efforts and suffering throughout this process have gone untold. We love Laila, and we would have done anything for her. Before my nieces were placed in any homes, I took Laila everywhere with me. She looked just like her Aunt Cat, so much that everyone in the family would call her my mini-me. She was more than my niece, she was my baby. and I was excited for her to experience life, to learn, to grow, and to hopefully see her continue to look like me for the rest of her life. We went through the proper steps. We had our home set up. We took the drug test. My brother was working through his case plan. It was Jennifer that didn't do the proper steps in line. DFACS put a stop to all of my wishes for Laila, overlooking our efforts, and instead placed Laila in a home that would be her last. While the defense tried to paint this pretty picture for you of the loving Rosenbaums with their 2 foster children, they also tried to focus on the mother's side of the family's flaws to try and make you believe that nobody in these girls' lives loved them like the Rosenbaums. But as we witnessed, that is not the case. We all love those girls more than they ever did or could. We heard a witness testify that grief comes in stages, and it usually takes 48 hours or 2 sleep cycles to get a full grasp on the trauma someone has experienced. Since I lost Laila, I've had nearly 4 years of sleep cycles. And my thoughts on the outcome of this trial have changed throughout these years. I respectfully ask that they both be sentenced to life in prison without parole, bringing them plenty of sleep cycles to come to terms with what they've done. To think of the pain they inflicted upon these girls, and to count up the days that they were so selfishly and hatefully took away from my Laila. Thank you, Your Honor, for giving me this time
All right,
to represent my family.
And please state your true and correct name.
My name is Caitlin Daniels.
All right, thank you, ma'am.
Thank you for the opportunity today to be the voice for my girls, Laila's sisters. 4 years ago, almost to the day, Millie and Laila moved into the Rosenbaum house. The girls were told they would be safe, they could trust them, and even that this was a good thing. However, 3.5 very long months later, we found out the truth. During their time living a life of hell on earth, these babies didn't feel like they had a voice. Even now, almost 4 years later, Millie is being made out to be a liar when in fact, Jennifer's the one who taught her to lie in the first place. Thankfully, we have all heard the evidence which supports Millie's statements back then and still today. Jennifer is the one who has been proven without a doubt to be the real liar. While Jennifer and Joseph have been free to live their lives for the past 4 years, Millie has been learning to live a life without her sister and learning to trust and feel safe again. Laila's younger sisters will live the rest of their life mourning a relationship they will never get to have. They will only know their big sister Laila through 2 short years worth of pictures and stories they will only hear secondhand. I teach my girls each and every day about choices and consequences. Jennifer and Joseph made horrible choices that will forever affect the lives of so many, but most of all Laila and Millie. Most of the adults in Millie and Laila's lives failed them repeatedly. It's time to show Millie her voice was heard and it matters. We need to show Millie and everyone else that what happened in that house is not okay. I want Millie to feel safe riding her bike in the front yard again. I want Millie to be able to trust her judgment in good and bad people again. I want Millie to believe in and trust the justice system when she is older. Now is the time, albeit long overdue, for Jennifer and Joseph to face the consequences of their actions or lack thereof in Joseph's case. I respectfully ask that you sentence both Jennifer and Joseph Rosenbaum to the maximum time allowed for each and every count they have been convicted of.
And ma'am, would you please state your full name?
Amanda Errol.
All right, thank you, and we appreciate you being here.
My name is Kimberly Fry, and I am Millie and Laila's great aunt. And I'm going to read my mother-in-law's impact statement for her, Peggy Banks. How has your heinous act affected my family? Let me count the ways. First and foremost is the obvious, the loss of my precious great-granddaughter, Laila Marie, which has left a sizable hole in our family and in our hearts. Laila will never experience her first day of school or look forward to summer vacations from school. She will never celebrate high school or college graduation, never have the excitement of her first date or looking forward to planning her wedding. Laila will never experience motherhood and certainly never give me any great-great-grandchildren, excuse me. All because of their selfish need to inflict the ultimate harm on a 2-year-old baby girl. Laila's death obviously had the most impact on her parents, but also affected her grandparents, great-grandparents as well, and not to mention aunts, uncles, cousins, including our children, and siblings. I'm most concerned about Millie, as she was most directly impacted, and in a negative way. This child has been in counseling and therapy ever since this happened. Her life will certainly never be the same. I fear the complete effect on Millie may be felt for years to come, possibly lasting the rest of her life. Now, Laila has 2 more little sisters who will never know or be able to love her as we did, never be able to play with her, look up to her, or call her their big sister. Your actions also negatively affected the Department of Family and Children's Services and the foster care system program, setting it back decades. The entire community has been upset over this murder. In fact, the family frequently heard from people in other states, some who traveled here to offer consolation and support.
Finally, your own lives are forever ruined as a result of their hatred and abuse of these sweet little girls who never hurt anyone in their short lives. And I hope they have a long, long time to think about their actions and all the lives that have been affected by them. Peggy, thanks.
Thank you, ma'am. We appreciate you being here.
My name is Kim Smith, and I'm Laila's great-great-aunt. That may sound like a very distant relative, but believe me, it was not. I wasn't there when Laila was born, but within a year she became a very bright, bubbly, sweet addition to my life. I am the last relative, besides Millie, that saw her and held her for the last time that she was alive. That day will haunt me forever. I saw something in her eyes that wasn't quite right, but I didn't act because I didn't know. Just the fact that the girls were in foster care impacted our family. It was dysfunctional at best. The girls were moved from pillar to post over and over. So when the Rosenbaums were to get the girls, we really did think that it would be a stable situation until our family could get them back. Fast forward to November 17th, 2015, the death of Laila and the trauma for Millie. Then the details began to surface. We mourned Laila, and we mourned with Millie. The media attention, we didn't ask for that. It was pushed upon us. Our family didn't want a civil case with DFAS. We wanted our Laila back. Lawyers, district attorneys, judges, all coming and going and changing. The case being scheduled and delayed again and again. This has been weighing heavy on our hearts for 4.5 years. From now on, we'll refer to our life before Laila died or after Laila died. We've had many people pray for our family, some from all over the world. Most all people you meet are disgraced by anyone that would harm an innocent child, much less beat a child until her internal organs tear and bleed and her bones break. To traumatize a child while she witnesses this happening to her sister, knowing it would happen to her as well. Jennifer and Joseph, you not only killed Laila and traumatized Millie for the rest of her life, you also broke the hearts of everyone that knew her and the hearts of your family as well. In my deepest time of grief and despair, I pleaded with God to let me just see Laila again. I didn't want to remember her lifeless, unrecognizable body in that baby coffin. That could not be my last memory of her. That night, Jesus gave me the sweetest dream of Laila in heaven. Laila's body is perfect now, just the way God created her to be. Oh, her hair is healthy again, not straw-like and falling out. It is shiny and longer now, like Millie's. And when she runs in the meadows of wildflower, it bounces. There is yummy food there, and she can eat it whenever she wants. There are ponies and puppies there, and kittens too. And Jesus always has time to play with her. There is so much love and happiness. There is no room for anger or bitterness. Everyone there is like family. But she really does have family there. Lots and lots of family. And she can't wait till the rest of us get there. Laila is in heaven, waiting for all of us. Thank you to everyone that prayed for my family. Jesus heard every prayer, and he comforted and loved on and provided peace to all that simply asked. Jennifer and Joseph, forgiveness has taken the place of hate and bitterness in my heart. However, we all must pay the consequences of sins, and according to the laws of this land, punishment of murder must be met. You have been found guilty, and I pray that you are punished to the full extent of the law. I also pray for your souls. To this day, I have not seen 1 ounce of remorse, 1 ounce of acknowledgement to the horror that you put these girls through. Yes, God will have the final judgment, and may he have mercy on your soul. Thank you.
Thank you. Thank you for being here.
Thank you.
All right. Does that conclude the state's evidence? One more?
Yes.
Okay.
I just have Daniel, and I'm Laila's mom. And I just wanted to say that they were given an opportunity to have a really precious baby in their life, and instead they took her life. And I've blamed myself over the last 4 years a lot for what's happened to my baby, because of my actions that caused her to be in their home. But I just want to say that now I see that I don't have to blame myself anymore because I never hurt my babies. I love them very much. And I just hope that the time that they do in there, I hope that they really have time to feel something. I hope that they can feel something. And
Thank you, ma'am. Thank you for being here. Right. Is there any weapons from the start?
No.
Ms. Wall, you have this confidence.
Yes, Your Honor. This is Michael Rosenbaum. Maybe I can stand.
Just right, we'll be fine.
Your Honor, my name is Michael Rosenbaum. I'm Joseph's father. I don't have a piece of paper on that in front of you, so I'm not prepared for this statement, but please be lenient. I know this all could have been prevented if the biological mother and the family, it started when that child was born, it starts with them. That's the first step of responsibility. This all could have been prevented if they would have took that responsibility and not limited yourself with drugs and alcohol. That's a sad thing. Alcohol and drugs are bad. But just please, minimum sentence, if whatever minimum, and he has CF and diabetes. Just please have the state take care of him and suicide watch. I know he wanted to take his life. Well, hey.
Thank you for being here. Thank you for statement.
My name is Mike Jackson. I've had the honor of knowing her for the last 6 months. She's worked with me. And I've heard all this stuff, but knowing her like I've known her for 6 months, most Christian lady I've ever met in my life. I've seen her stay after work and make gifts for the kids at her church. And I go to my grave thinking she did not kill that child. The child died, but I think it died with her trying to save it. That's all I can say.
All right, is there any other evidence from the defense?
Come up here.
My name is Casey Valentine. I don't know the Jennifer that has been portrayed in this courtroom. I know a smart, funny, kind, generous, and faithful person. I respect our justice system and I respect this process, but I fear this time they got it wrong. I've had many people question my loyalty to Jennifer during this ordeal. But the things said in this courtroom and the accusations that were made are completely inconsistent with the person that I know. She's been through more in her short lifetime than most people ever have, and she thrived. Jennifer and Joseph were broken by the death of Laila, completely broken. They loved those girls with their whole hearts. The ripple effect of this accident is so far-reaching, as evidenced by all of the people here today. But I do believe that's what it was, a tragic accident. They will never recover. No one in this room will. I respectfully ask you to have mercy on Jennifer and Joseph to the extent that you're able.
My name is Summer. I was with those girls most of the summer that year. There was nothing wrong with them. They weren't hurt. My son knew them. He grew up with them. We went with them everywhere. My sister and my brother-in-law, like that they were their own. And my son is going to be in pieces when because that what he's never going to see or again, or whatever you choose. I believe in the justice system, but they did get it wrong this time. And they didn't prove anything when they stood up there and did their whole thing and whatever else they did. But my son, he loves them with everything in them. And his 10-year-old self is going to be very upset when I go home to tell him that he's never going to see again. And every time I show him pictures of Laila and Millie, he talks about them too. And so I know that they got this wrong this time. And the death threats we've been receiving and everything we've been receiving from that side of the courtroom and their little group and everything like that, for them to sit up here and say the things that they've been saying about my family and Jennifer and Joseph is beyond me. So please.
Your Honor, I don't have a speech. I didn't know I was going to be coming up here, so I'm just going to speak from my heart. I'm Joseph's mom, and I've known Jen for 10 years, since 2009. Everything that I feel in my core, anything that I have ever seen, they were good parents, both of them. They would never do this. It was an accident. I don't care what anybody says. Please, be lenient on them. My son is going to die in prison because they're not going to take care of him. Like he said, the care that he's needed on the outside. So I've lost my son. And not just to prison, but I have actually lost my son. I'm sure. So please be lenient. That's all I ask. Thank you.
Ms. Small, thank you. Let's turn to argument. I think it's the right opening.
Yes, good. I will start with the matter of the indictment, what charges will be vacated as a matter of law and which ones will not. I would say that as counts 3, counts 5, and counts 7 would be vacated as a matter of law into count 6, the felony murder. That's pursuant to Anthony versus the state, 303, Georgia at 399. It's a 2018 case.
Vacated in count 6.
That's correct. Which is the felony murder. The court's sentencing options as far as the felony murder count, the only options the court has is life or life without the possibility of parole. As far as Mr. Rosenbaum, he was convicted of both counts 8 and counts 9. Count 9 would be vacated as a matter of law into count 8. The penalty range for murder in the second degree is 10 to 30 years. As far as the aggravated assault and cruelty to children, pursuant to Kurt versus the state, which is 309 Georgia Appeals 227. I have a copy for both defense and for the court. Because aggravated assault and cruelty to children in the first degree have different elements that are not present in the other one, as a matter of law, they actually are not vacated, and the court can sentence both of them, sentence the defendants for both of them. So that would be, for example, counts 10 and 11. Pursuant to that case law, they actually would not merge as a matter of law. The same is kind of true throughout the entire indictment. Counts 12 and 13 are related, but pursuant to the case law, they do not merge. Counts 14 and 15 are related, but pursuant to the case law, they do not merge. They're not vacated as a matter of law. 16 and 17, 18 and 19. If you need to slow down, I can do that, Judge. The cruelty and children. I guess
you're telling me which counts are not vacated.
The aggravated assaults and the cruelty to children counts that I guess are related when you look at the dates. They do not merge as a matter of law. The court can sentence them separately. The same is true with cruelty to children and aggravated battery, because that similarly has an element specifically. Cruelty to children requires cruelty to children, but not aggravated battery requires proof that the victim was a child under the age of 18 who was caused cruel or excessive mental pain. Aggravated battery, but not cruelty to children, requires proof that the victim was deprived of a member of his or her body, or in this case, as was indicted, such member was rendered useless or seriously disfigured. That is pursuant to Waits, W-A-I-T-S, versus the state. That's 282 Georgia 1. That's a 2007 case from our Supreme Court. Similarly, the aggravated battery counts and the cruelty to children counts that have the same date, as a matter of law, they actually are not vacated. The penalty range for aggravated assault, cruelty to children in the first degree, and aggravated battery, each of those carry a penalty range of 1 to 20 years for each of them. As far as the remaining charge that is different than the other ones I just discussed, that would be counts 48 and 49, cruelty to children in the second degree. The penalty range for cruelty to children in the second degree is 1 to 10 years. So the penalty ranges for murder, as I mentioned, there's life without parole. Murder in the second degree is 10 to 30. Aggravated assault, for cruelty to children in the first degree, and aggravated battery are all 1 to 20. And cruelty to children in the second degree is 1 to 10. Your Honor, as far as argument is concerned, a jury of the Rosenbaum's peers has spoken. This jury clearly deliberated long and hard and came to a very wise and just verdict given the facts that were elicited during the course of this trial. The state is asking, given the egregiousness of this crime, that the fact that this was a 2-year-old victim, that under no circumstances could have ever done anything to either of these two individuals to provoke any of the treatment that they received while living in that home. The fact that there was prior abuse that was shown, and the jury has convicted them not only of the things that were committed on November 17th of 2015, but they were convicted of abuse that occurred prior to that day as well, which was borne by the evidence, specifically multiple fractures, healing fractures, and the evidence that Dr. Darasol was able to see under the microscope that you testified here today. This was not a single incident. This was a pattern of abuse, and given the egregiousness of that, as far as Jennifer Rosenbaum is concerned, the state is seeking a sentence of life without the possibility of parole. Plus, she is also facing, if you total up the remainder of the charges, she's facing a total of life without the possibility of parole, plus 780 years. The state is seeking life without the possibility of parole, plus all counts to run consecutive. As far as Joseph Rosenbaum is concerned, if you add all of the charges up, Mr. Rosenbaum is facing a maximum possible penalty of 410 years in the Department of Corrections. The state is seeking a penalty for Mr. Rosenbaum of 70 years to serve 50 years in custody, the balance of which to be served on probation. We think that given the evidence that the court has heard during the 3-week trial, I think that these sentences are just, given the egregiousness, the seriousness, and the vital things that we heard that occurred in that home. So for those reasons, Your Honor, we would ask the court to follow the state's recommendation.
I want to talk first about Joseph Rosenbaum. Joseph Rosenbaum suffers from cystic fibrosis and has diabetes. His life expectancy is less than half of what the state is asking for in this case. He is faulted with not taking action, which is an act of negligence, is what the jury found. And even if we accept, which we do, the verdict of the jury, they have found him to be negligent. They have found that he was a party to a crime as to the other counts. Your Honor, there was no evidence that Joseph knew or should have known, and that's not even the standard. The standard is that he knew. There was no evidence that he knew. But given the jury's finding, I know the court has to make a decision. I'm asking the court to consider a much less sentence, given the fact that this is for negligence, for a negligent act. He was working 2 jobs at the time. He was a correctional officer, and he was working security at Lowe's. He didn't have much time to be around the girls. What time he did, according to the evidence, he was good to them. That was the evidence that was brought out, that he was good to them, that he treated them well, and that he didn't do anything to them. I don't think that warrants 70 years. I think that warrants 5. Your Honor, I would ask you to consider, as I say, the shortness of his life, and that we are not all sum total of what we do on one day or what we fail to do on one day. These both, Jennifer and Joseph, come to you with absolutely no record whatsoever. They come to you having had no brush with the law whatsoever. Jennifer, Your Honor, was a law student. She was a very good law student. She did a lot for a lot of people, and the girls no lesser than anybody else. As we have heard, the evidence is that she did love them, she did give them the love and care that one would expect. We differ with the jury as to the cause of death, but we understand responsibility, and Jennifer understands responsibility and has always blamed herself. I'm asking that you consider a life sentence for her, and that you not, we have had many criminals come up with life sentences as opposed to life without parole. We reserve life without parole for the most egregious. Jennifer Rosenbaum is not the most egregious of people. She grew up in the foster care system. She was a child of defects for the longest, and she did what she could and what she knew to do best. I'm asking that you consider a life sentence for her. I'm asking the court that you consider the least amount of time you can give for Joseph in this case, and to stack counts against Jennifer defeats the purpose of rehabilitation. This is somebody who comes with no record. Both of these individuals have no record. They have been contributors to the community. You've heard that repeatedly, both during the trial and after the trial. These are not people who have sucked from the community, but instead have given to the community. Again, we are not the worst that we have been on one day. We're made up of more, and I'm asking for mercy for both of these young people, and that you consider minimum sentences for them both. Thank you.
Thank you, Ms. Small. Any final thoughts? Briefly, Judge. As far as Mr. Rosenbaum is concerned, Ms. Mull is right in that murder in the second degree is based upon negligence. But that negligence cost Laila Daniel her life. That is the most negligent thing that a person could possibly do, knowing that abuse is going on in the home and doing absolutely nothing about it, leaving Laila in the care of the person who is abusing her. The evidence that he knew was Millie's statements. Millie mentioned that he knew that he would stand there and he would watch. We also heard from Ms. Lambert that Millie actually told her that Joseph had hit her. We know from Millie's statements that he would put icy hot on their wounds, and that he also did nothing regarding the fractures. Millie, when Millie went to the hospital on November 17th, 2015, that was the first time anyone had ever realized that she had a fracture as well, a fracture that would have been painful, a fracture that the doctors testified that any person around a child with that type of fracture would clearly know that it was going on. He did nothing. That negligence has cost Laila Daniel her life and has forever changed Millie's life. For that, I think the state's recommendation is more than reasonable as far as 70 years to serve 50 years in custody. As far as Mrs. Rosenbaum is concerned, Ms. Mull first said, well, one of the last things she said to this court was that we are not the worst of what happened on one day. I have to remind the court this is not something that happened just on one day. This was a pattern of abuse that occurred over a relatively short period of time, but it was a pattern of abuse that was incredibly increasing. It was a pattern of abuse that ultimately cost a 2-year-old child her life. And to say that that is not the most egregious thing that this court would ever have to hear is astonishing to me. This has to be one of the most egregious things. When a 2-year-old child is punched or kicked or stomped with blunt force to her torso, severing her pancreas into two, lacerating her liver and her mesentery to the point where she bled out in less than an hour. The final moments of her life, as Dr. Darasaw testified, would have been her bleeding internally, going into shock, and ultimately dying in front of the person who killed her. Those were the last moments that she had on this earth. I can think of nothing more egregious than that. The state asked that the court follow the state's recommendation of life without parole, plus the remainder of the counts to run consecutive. All right.
going to take just a few minutes to review the cases that Mr. Chase has submitted, ensure that they're correct, and I'm going to return with the sentence. During this 10-minute recess, I expect that decorum will be observed in the courtroom. There'll be no outbursts or crosstalk. That's between people who are here in support of the defendants and people who are here in support of the state. If you cannot abide by those instructions, then you'll be immediately asked to leave. I hope everybody understands. I'll be back in just a few moments. Thank you both for your argument.
May seated, come to order.
Okay. There'll be order judgment in court. Ms. Jennifer Rosenbaum, would you please stand. There'll be order judgment in court that count 3 be vacated and count 6. That count 5 be vacated and count 6. As to count 6, you'll be sentenced to a term of life in prison. As to count 7, it's vacated into count 6. As to counts 10 through 41, you'll be sentenced to a term of 20 years to serve. Those 20 years will be served concurrent with each other and consecutive to the sentence pronounced in count number 6. As to counts 42 through 47, you'll be sentenced to a term of 20 years. Those sentences will run concurrent with each other and consecutive to count number 10. As to count number 48 and 49, you're to receive 10-year prison sentences, and those are to run concurrent with each other and concurrent with the other sentences that the court has imposed. All told, this is a life sentence, plus 40 years to serve in a state penitentiary. You have 30 days from today's date to file a notice of appeal. You have 4 years from today's date to seek any habeas relief that you deem appropriate under the circumstances of this case. You may be seated. Mr. Joseph Rosenbaum, please stand. In the order of judgment of this court to be sentenced to a term of 30 years in state penitentiary. As to count number 8, count 9 will be vacated and count number 8. As to counts 12, 13, 14, 15, 18, 19, 22, 23, 26, 27, 30, 31, 42, 43, 44, 45, 46, 47. You'll be sentenced to a term of 20 years to serve in the state penitentiary. Those sentences are to run concurrent with the sentence that's been pronounced in count number 8. As it relates to count 48, you're sentenced to a term of 10 years on probation to run consecutive to the sentences pronounced in counts 12 through 47. And as to count number 49, you're sentenced to a term of 10 years on probation to run consecutive to count number 48. All told, yours is a 50-year sentence with 30 years to serve in the state penitentiary. Sentence having been pronounced, you may have to see. I should also say the same to you that I said to Mrs. Rosenbaum, that you will have 30 days from today's date to file a notice of appeal. You'll have 4 years from today's date to file for any habeas relief that you deem appropriate under the circumstances. counts here. Let me just double check with the state and with the defense that we have covered them appropriately in terms of completeness and in terms of calculation.
Yes, sir. It appears that all the counts for which they convicted, they were sentenced on.
All right, and the pronouncement as calculated appears to be correct.
And Judge, if I could just add one thing regarding the merger. One of the reasons why the counts merged into the felony murder is because that was the act that actually caused the death. The other actions in the indictment on November 17th were not the cause of death; they were simply other injuries that were on the child.
All right, and so I've correctly stated your position regarding what counts are to be vacated.
That's correct.
All right, and let me just also add that it is deeply frustrating for the court to hear family members of the defendants quarrel with the verdict that was rendered in this case. This case was carefully tried. And I'm deeply concerned of the lack of recognition on behalf of the defendant's family of the scope of the tragedy and of the cause of the tragedy. I've lived with this case for a long time too. I will tell you that it is one of the worst, most horrible crimes and outcomes that anyone could ever experience or dream of experiencing. And so I just want to say that I feel for and deeply pained by your loss. And I hope that you will somehow find a way to recover. Sentence having been pronounced. Is there anything further from the state?
Nothing from the state.
Training further from the police?
No, you could sit on the telephone, you.
I will not. Thank you. I'll conclude this matter. Your turn.
All right. Well, what the judge said there was, absolutely correct. Yeah, I would have been more in. I would say I would look at the family and say, "You are all an embarrassment." It's as if you didn't have any regard for the child that was murdered and care more just about how much time your living child will, or daughter or sister, is going to spend in prison. I just would have gone off for like 10 minutes, listening to these idiots. Hey, did you cry when the baby died? When the child died, I mean? You guys are sick. Anyways, thank you guys for reaching the goal. I should have set it higher since we hit the goal at with 3 hours to go, and after that it went. Anyways, let's see. Let me get to the. So thank you to K. Me, Cheryl Bullock, Trisha, Circa Then, Danny ICURN, and Mama She 13 with a cat eye. Without that one, we wouldn't have made it. And then Danielle, Daphne, Saul T, Deborah Blum Rogers, Mama She 13, and Shelly Ann. Awesome. All right, guys, we'll see you on the show tonight. I'll try to figure out what to. Might do one tomorrow. Not really sure. Who knows? And thanks for everybody for watching it. We did 8 days of it. I think there was like 16, but wasn't enough people watching.
Drama! It's a house! Bitch, please!
Dude!
Mr. Martinez, are you angry at me? 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 Mr. Martinez, are you angry at me?
Yeah, thanks for the recommendation there, Daphne. That was you, yeah. So cool. Yeah, I mean, it was one of those sad ones. Just like the Hart family case never went to trial because everybody was dead. But they had a coroner, like, inquest, basically, on that one. That one was pretty interesting. I wonder if I still have that somewhere. So I think I had the recordings of that. Maybe that would be an interesting one to just play the inquest on it. Now that case was ridiculous. 6 kids all used for their foster, or their, not just foster, they weren't even foster kids, they were adopted, but the Texas pays monthly, and they were just used for that. And even though they didn't live in Texas, they kept paying them. That was sick as hell, man. And they were just plump ass. I want to call them the B words. Yeah, and the kids were just all starving to death. They hardly got any food. The refrigerator's filled with food, but wouldn't let the kids eat any of it. I mean, just how does somebody think like that? Isn't that amazing? Like, where does somebody's evil spirit come from? And then Sarah Hart in that case was just like the guy in this one. And Jennifer Hart. It's weird how all the Jennifers are psychos. You got a Jennifer in this case. And yeah, it's just, that's horrible. Yeah, I'm talking about the Hart family, Danielle. I mentioned it like 3 times. What do you mean? Is that the Hart family? God. Yeah, so Jennifer Hart and then Sarah Hart is like the husband in this case. And Jennifer Hart is like Jennifer Rosenbaum. I mean, almost exactly the same. Just absolute nut jobs. And these kids, you know, once it was found out that that they were starving their kids and abusing them, they realized the jig was up, right? So then they, I think they must have been planned together. Like Sarah and Jennifer decided to drive away and then drug everybody up with some cough medicine and then drive or allergy medicine, I guess, and then drive off of a cliff on the California coast, killing everybody. And the only one that wasn't ever found was Devante. And I actually think he was killed and placed somewhere else prior, because he's the one person, he was sort of the golden child, and he's the one that led to the downfall. And I think that they treated him differently, and they put him somewhere else. Yeah. Oh, yeah, it can be kind of noisy out there. All right, everybody, thank you. We'll see you guys later. Be safe out there.